come into force, that will prevail. Other difficulty. What is the difficulty in that? No, no, no.
My lord,
See, you have only been issued with a notice. Go appear before the authority and.
Lord, I have replied that has been considered as an appeal and an order is passed, and they have not provided me with a copy of the order. Let them maybe directly
Pointed out.
provide me the order copy.
So an order is passed by the authority. Then you will have to go before the appellate authority.
Not aware what under what provision.
Adema.
Directly the order.
Won't make the same submission before the appellate authority. The appellate authority will not listen to you, is it? Then, which is that provision? This is 2023. One 142.
Subsection
148.
Yes.
Subsection 2.
Seeks to appeal against the demand notice issued by the chief or any person authorized by the such a person may file an appeal before the tribunal in such a manner or right.
On the previous occasion, the learned counsel for the respondent BBMP had pointed out that the appellant has an alternative expeditious remedy before the Karnataka Appellate Tribunal in terms of subsection 2 of section 148.
It's called mysterious appeal.
Where do you get that? Where do you get that information, sir?
Appeals are pending.
There has to be a provision. Which is that provision? Huh?
Before the trial, such a manner as may be discovered.
Read. Section 262. Tribunal means Karnataka Appellate Tribunal.
Counsel for the respondent BBMP had pointed out that the appellant has alternative applicable remedy before the Karnataka Appellate Tribunal in terms of section
2 of section 148 of the Brihat Bengaluru Mahanagara Palike Act, 2020. Stop. Learned counsel for the petitioner had sought for a short accommodation to get back after going through the relevant provisions. Full stop. Next para. Although time was granted as requested by the learned counsel for petitioner, the learned counsel is unable to convince this court that the petitioner need not approach the tribunal to avail of the appeal remedy provided under the statute. Full stop. Next para. In that view of the matter, this writ petition stands disposed of, granting liberty to the petitioner to approach the appellate authority as provided under subsection 2 of section 148 of the Act. Full stop. Ordered accordingly.
Protection till I approach the tribunal.
ಏನ್ ಮಾಡ್ಬಿಡ್ತಾರಮ್ಮ? ಏನ್ ಮಾಡ್ತಾರೆ? ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ? They will come and say why you should not execute. By that time you go and file your appeal. This is not a case for demolition of the building. Anta urgency ಅಂತ ಹೇಳೋದಕ್ಕೆ. Yes. ಎರಡು ಒಂದೇ. Yes. Yes.
Small shop owners unit, and they are in the bus stand commercial unit. And the respondent number 3, the instance of respondent number 2 has issued the eviction notice and for they are tenants since 15 years and continue to pay the tenant rent and electricity bill.
Where is the notice?
It's in Technic.
Where is the notice?
Annexed
Into notice
F series.
F series. ಏನು ಹೇಳ್ತಾರೆ?
They want to evict the petitioners and give for a fresh public auction for giving a fresh rental.
Please see section 72. Please see section 72 of the Municipalities Act.
They have not followed the proper procedure in.
ಅದನ್ನ follow ಮಾಡೋದಕ್ಕೇನೆ they have given you notice.
It was in
You can't-
2019, Your Honor. Notice is being given in 23.
When was
Respondent
the lease granted to you?
lease granted 15 years back, Your Honor.
ಅದೇ ಮತ್ತೆ
And continue to be.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. Only a maximum period of 5 years lease can be given. Please see section
Yes,
72.
Your Honor. It is
So
not.
therefore, the government has issued circulars and has directed all the municipalities to ensure that the old tenants are vacated and new tender notifications are called for.
Yes.
They are accordingly doing this.
2019, they have issued the circular.
ನೀವೇ ಹೇಳ್ತಿದ್ರಲ್ಲಮ್ಮ 15 ವರ್ಷ ಆಯ್ತು ಅಂತ.
Lapse of the time, Your Honor, after the circular was issued in 2019, they have come before this, the tenancy continuing to be as a tenants. In 23, they have, all of a sudden they have come for the public auction.
Learned AGA
And
takes notice for response number 1 and 2.
Honor, one more similar.
Issue notice to respond number 3.
There is an interim
Learned
order.
counsel for petitioner is directed to serve 2 sets of copies of the writ petition on the learned AGA.
In similar petition of petition 7618, interim order for disposes the, they are very small shop owners here.
Small big
ಅದು ಈ ಕೇಸ್ ಆಗೋದಕ್ಕೆ ರೆಂಟ್ ಪೇ ಮಾಡ್ತಾರೆ. They are not illegal tenant, default tenant ಮಾಡ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ರೆಂಟ್ ಕಟ್ಟಿಲ್ಲ ಅಂತಲ್ಲ, ಅವ್ರು ಕಟ್ತಾ ಇದ್ದಾರೆ. ಅದು ಓನ್ಲಿ ಪಬ್ಲಿಕ್ ಆಕ್ಷನ್
ಯಾವ್ದು ಅಮೆಂಡ್ಮೆಂಟ್ ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು?
ಅಮೆಂಡ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಶಾಪ್ ಓನರ್ ಒಂದೇ ಒಂದು ಇದಾಗಿತ್ತು ಅಷ್ಟೇ ಸ್ವಾಮಿ, ಅದ್ರ ತಪ್ಪಾಗಿತ್ತು. ಒಂದು ಶಾಪ್ ಇದ್ರದಲ್ಲಿ.
That is correction. It is not an interim order.
Interim order has been granted, Your Honor.
ಇಲ್ಲಿ ಓದಿ.
Subject to.
ತೋರಿಸ್ರಿ ಅವ್ರಿಗೆ, ಕೊಡ್ರಿ ಅವ್ರಿಗೆ. That application is for amendment. ಇದರಲ್ಲಿ ಶಾಪ್ ಹೆಸರು ತಪ್ಪಾಗಿ ಬಂದಿದೆ, ಅದನ್ನ ಕರೆಕ್ಟ್ ಮಾಡಿ ಅಂತ ಬಂದಿದ್ರು. We have corrected it. Where is the interim order?
ಇಲ್ಲಿ ಶಾಪ್ ನಂಬರ್ 35 ಅನ್ನೋದು ಎರಡು.
ಅದೇಮ್ಮ ಕರೆಕ್ಟ್. ಆ ಮಿಸ್ಟೇಕ್ ಆಗಿರೋದ್ರಿಂದ ಅದನ್ನ ಅಡ್ವಾಂಟೇಜ್ ತಗೊಂಡು ಏನು ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದ್ರದ್ದು ಮುಂಚಿತ ಆರ್ಡರ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಕ್ ಮುಂಚಿತರಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
Yes. Yes, next matter please.
(269) of the Gram Panchayat Act is challenged.
Huh?
Executive engineer has passed an order under 269 appeal.
Who approached the executive engineer, executive officer?
No, my lord, this case now the petitioner has not approached the executive engineer. So this is a case.
Executive officer of the Taluk Panchayat. Who approached?
Lord, it was not. That is why, my lord, it was earlier a complaint was given by a representation, my lord, by one person.
Okay.
Lord, the respondent number 3 has given a complaint. By way of representation, my lord, I may permit it. It's in my hand, my lord, I may permit it. But he. 5th January 21, my lord, he made a representation, my lord, in the subject, saying that, my lord, the PDO, it's a property belonging to the Chatra and it's a Mudra department. he has, my lord, wrongly mutated the name of the petitioner in the property and they were alienating the property and he made a representation. This, my lord, he has treated it as an appeal. The next page, my lord, the page number 5, my lord. Lord, he treated, my lord, the SS Venkatesh, my lord, as an appellant. And, my lord, the petition number, respond number 2, Srimati Pushpa Narasimhan, as a respond number 2. And, my lord, without giving an opportunity, he passed an order saying that, my lord, it's a property belonged to the Muzrai department. And it could not have been, the Khata could not have been issued on the name of petitioner. This order was challenged before this honorable court, my lord, in a writ petition. That, my lord, Annexure G, my lord, page number 59.
This was of year 2021.
Please, my lord, this was challenged.
18/1/2021.
Please, this was challenged for this honorable court, my lord, Annexure G, page number 59. It was attested on the ground, my lord, the no notice was issued on the petitioner. And matter was remanded back. After remand, my lord, Annexure K is the now order which is impugned. Annexure K, my lord, page number 83.
Yes.
It is dated 9/1/20.
Correct. Now opportunity is given to you.
Please, it has been given, my lord. Now, my lord, I have been treated as an appellant in this Annexure K. Please, no, my lord, this is a case wherein, my lord, the Dharma Chatra, which they are saying, my lord, in the first earlier order, my lord, they say, my lord, now they are saying it's a belonging to the one Devasthana, my lord, it's a temple. Gangadeshwara Swami Magu, Vannadevi Devalaya, anta. They say, my lord, it was established by for that purpose for the devotees who has approached. In fact, my lord, this Dharma Chatra has been built up by my petitioner's ancestors. Annexure A, my lord, it's a property in which, my lord, the husband of the petitioner's father has inherited it.
When it was declared a Mujra institution?
No, my lord, it was after coming in Inam Abolition Act. It's all the lands where Inam petitioner's ancestor owns 242 acres.
Yes, but when it was declared a Mujra institution?
Please, my lord, that has not been declared. It is our case, my lord. It's our ancestors' Dharma Chatra we've been running and we are the Vyavasthapakar. We are taking care, my lord. No, my lord, they suddenly come and say, my lord, it's a Muzrai department and we are no concern. It's such a.
Okay. Issue emergent notice to response number 1 and 2. Issue to all the respondents. Returnable by new Tavatirandre for Taluk Panchayat and Panchayat. Learned Counsel Shri MS Devraj, who is present in the court, takes notice for respondents number 1 and 2. Issue notice to respond number 3. Learned Counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on Learned Counsel for respondent number 1 and 2. We'll stop. Next para. Learned Counsel for the petitioner submits that earlier, when the first respondent executive officer of the Taluk Panchayat had passed an order directing the removal of the name of the petitioner from the Khata register of the second respondent, Sompura Gram Panchayat, the petitioner herein had filed WP number 4443 of 2021. Stop. This court, by order dated 12th of September 2022, set aside the order and directed and remitted the matter back to the executive officer to afford an opportunity of hearing to the petitioner and thereafter pass necessary orders. Full stop. Learned counsel submits that although it was brought to the notice of the executive officer that the property in question is a private property belonging to the petitioner's forefathers, they having acquired the same under orders passed by the land tribunal. Land tribunal, sir? How can the executive officer decide this question, sir? Under which provision? The executive officer can decide this, is it? It's a matter for stay. Amel Bani Nivo. You will see.
Also, the petitioner submits that although it was brought to the notice of this court to the executive officer, the property in question is a private property belonging to the petitioner forefathers having acquired the same passed by the land tribunal.
By orders passed by the land tribunals. Nevertheless, the executive officer has proceeded to pass the impugned order at Annexure K, directing the removal of the name of the petitioner from the Khata register and to enter the name of the government as the property is a Muzarai institution property. Stop. Learned counsel submits that a disputed question of title cannot be decided by the executive officer under section 269 of the act. Please try to analyze. You will have to analyze and say which is the provision, what is the powers, whether he could pass this kind of an order. One sentence ಹೇಳಿದ್ರೆ ನೀವು But you did not say anything. You are only repeating what had happened earlier. You never said he has no such powers to decide the question of title.
Sorry.
Consequently, there shall be an ad interim order of stay of the impugned order at Annexure K, till the next date of hearing.
Be pleased to your lordship. Your lordship, this is very similar to the previous case, wherein the executive officer has exercised the powers which is not vested in him in deciding the title of the petitioner. Be pleased to your lordship.
Yes.
The chief officer, Karnataka Town Panchayat office, has committed a serious error in reaching to the conclusion that the properties held by late Srimati Bhagyamma, wife of the petitioner herein, belong to her by virtue of a gift from a parent family, and hence, in the absence of any children to late Srimati Bhagyamma, the property reverts back to her parental family, that is to her siblings.
But here you are asking for entry of your name in the Khata register.
Yes.
And the chief officer of the town panchayat has issued this impugned endorsement.
Yes, your lordship.
Declining to accept your application.
Yes, your lordship.
Yes, perfect.
Your lordship, this was by virtue of a registered will.
This is not a case where interim stay can be granted. Matters to be decided after they appear.
I will just convince your lordship on one.
Madam, they have to come. Without their presence, can we decide this matter? Issue notice to the respondents. Yes. Huh? BBMP. Which is the type of order that you want? Which is the type of order that you want? Annexure L. Page number?
Stay granted by this honor. Page number 76. Annexure L.
Either tarana same,
Please.
except the change in the date
Please.
of the demand notice. Aste bere changes illa. Page number 76 alli the annexure L. Same type of note. Learned AGA takes notice for respondents number 1 and 2. Learned Counsel Sri Pawan Kumar, who is present in the court, takes notice for respondents number 3 and 4. Learned Counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on Learned Counsel for the respondent BBMP and a copy on the Learned AGA. Yes. List number 2.
The petitioner has acquired the property and grant the 16/1/1989 by the Land Reform Tribunal. That the said order Malan the challenged by the one villagers. That the order was the appeal was dismissed. But thereafter the villagers one villager along with the 4 villagers have challenged that order in the civil court for declaring that the order of the land tribunal has null and void unto permanent injunction. That suit decreed by the trial court. Again, the state has prepared an appeal and the petitioner has prepared an appeal before the appellate court. Both appeals are dismissed. Against which the petitioner has prepared an RS. This is the pending report. This order it was admitted for the final hearing. But such being the case, but the respondent number 1 and 2 and 3 are interfering the position and they are digging the land and trying to construction the property. But earlier to that,
What is the prayer in the petition?
For the petitioner has put the representations before the authority. But earlier, the 1966 land was notified in the name of the father of petition. Father of the petition.
You cannot have any remedy before this court in writ jurisdiction.
I have filed the representation.
RFA pending ideyalla alle you have to take some
annexure M please. Annexure M. But the accusations agide.
Not for
kadata kuda namage enu adu labyate illa anta helkodtare. Annexure M page number 1.
See your prayer. You tell me whether this prayer can be granted. It's a civil litigation. Only a civil court can decide the matter. How can this court direct? No, not to interfere. Is it not an order granting temporary injunction? Is it permissible?
Without any issue.
You alle application hakkali, get an order of temporary injunction. Barkali.
In the moment,
Learned AGA takes notice for respondent number 1.
annexure M11.
Notice to the other respondents is not necessary for the following reasons. Next para. The prayer in the petition is to direct the respondents number 2 and 3 to consider the representations given by the petitioner and to restrain the respondents from illegally making construction in the property belonging to the petitioner. Stop. It is clear from the submissions made by the Learned Counsel for petitioner that there is a civil dispute between the petitioner and respondents number 2 and 3.
Respondent number 2 and 3, they are not parties in the dispute.
Matte yaru?
Only the land tribunal and the villagers are the parties.
Yenadamma?
here submission made to the counsel for the petitioner that there is a civil dispute between the petitioner and respondent number 2.
Petitioner and the local villagers. Stop. The contention of the petitioner that he is the owner of the property by virtue of orders passed by the land tribunal has not been accepted by the trial court. Stop. It appears that the petitioner has filed a regular first appeal in RFA number RS regular second appeal in RSA number
1352
2013, which is pending consideration before this court. Full stop. The prayer made in the writ petition is in the nature of granting an order of temporary injunction to restrain the respondent authorities. Full stop. Such prayer cannot be granted by this court under the writ jurisdiction. Full stop. If the petitioner is aggrieved by the action of the respondents or the local villagers, the petitioner will have to seek an order of temporary injunction at the hands of this court in the pending regular second appeal. Full stop. Next para. With these observations, the writ petition stands disposed of.
Number 2. Within the rate. Arun Kumar.
1 ಇಲ್ಲ 2 3 ಮತ್ತೆ 5 ಅನ್ಕೊಂಡು.
Number 2. What? Venkatagama. Venkatagama serial number 2. Which number? Which number 2?
ಬಂದಿದ್ರಲ್ರಿ ಇಲ್ಲೇ ಇದ್ರಲ್ರಿ. ಯಾವುದು
Number 3.
ಇದೀನ ಅವ್ರದೇನೆ
Number 4.
5
A. Mahesh Chaudhary. Mahesh Chaudhary.
ಆಮೇಲೆ ಮತ್ತೆ ಒಂದು ಸರಿ
Number 1. Vision.
ಎಲ್ಲ ಸೇಮ್ ಆರ್ಡರ್ಸಾ 8 9 10 11 ಹಾ ಯಾವ್ದ್ರಲ್ಲಿ
Serial number 8.
ಸೀರಿಯಲ್ ನಂಬರ್
8, 9, 10.
ಹಾ ಸೇಮ್ ಆರ್ಡರ್.
Same.
ಒಂದು ನಿಮಿಷ. ಬಸವರಾಜ್ ಬೆಳವಿಗಿ 2 ಮ್ಯಾಟ್ರು, ನಾರಾಯಣ 2 ಮ್ಯಾಟ್ರು.
Number 12. Madhua. Number 12. Madhua.
Petitioner. This is the petition, but the petitioner is the owner of the property. The respondent is a tenant from 2019, my lord. The rent was fixed for a 2,01,000
ಟೆನೆಂಟ್
tenant, my lord. And there is an agreement, the annexure E. As per the clause 50, my lord, there is arbitration clause. From last 2022 January, the respondent is not paying rent, sir. Therefore, the petitioner has issued notice to vacate the premises and to clear the rents. But till today, the rents has been not paid.
Where is the arbitration clause?
Arbitration clause at page number 45, my lord, clause number 50, annexure E.
Future Retail Limited
Yes, yes, my lord.
is the lessee.
Yes, my
Who is the lessor?
lord. Lessor is a Suresh GM, my lord.
Where is it found?
It's in page number 38.
Huh?
Lease date. my lord.
Yes. 45.
Yes, yes, my lord. Clause number 15.
Yes.
The petitioner has issued notice at annexure W, my lord, for appointment of to give a consent to appoint the sole arbitrator. But notice was-
Annexure F is what?
Annexure F is when they have failed to pay the rent, sir. So we have issued a caution legal notice to make the payment, my lord. And then they have refused to make the payment. That is rent, my lord. Again, we have issued notice on at annexure N, my lord, page number 64, to vacate the premises, my lord. Clear the rents and to vacate the premises. Even then, they have failed to make the
Issue notice to the respondent.
The application clause not been paid, page number 73, that's the contract. The respondent department for gate separator construction. There was an earlier CMP file which is premature, 73 at 24.3 minutes. 24, page number 73 minutes at annexure A.
73.
73 minutes, 24.3, the arbitration clause. Bottom of the page. Arbitration shall be made. Arbitration should be conducted in accordance with the arbitration procedure stated in the special conditions of contract. That minutes will find it page number 82 minutes. Special condition clause number 4. That's the procedure prescribed these minutes. In the event there is a dispute between the disagreement between me and the respondent minutes, one of the appointing authorities in the initial
Principal secretary.
minutes
It will be held by principal
No, it should
secretary.
be held at the office of the principal secretary. Minutes
Arbitration proceedings shall be held at.
Yes, at the chambers of principal secretary. Procedure is in the event of disagreement minutes, one of the annexure, one of the institutions in annexure minutes at the bottom of the page. One of them will have to first appoint an arbitrator. Minutes, what happened is minutes after the invocation notice was served and no response came from the respondent minutes, we filed a CMP. Minutes that was disposed of as being premature, that minutes will find it page number 179.
Because you are not issued a notice for arbitration.
No, minutes. I issued a notice for arbitration. I had to go approach one of the institutions in the annexures to seek for appointment of arbitrator.
Yes.
That minutes was disposed of, reserving liberty in my favor to approach one of the institutions.
Yes.
I went to Indian Council of Arbitration in the month of October 2022 minutes. I wrote communications minutes. They in fact acknowledged that minutes will also find it page number 201. Minutes 185 minutes is my letter to the institution Indian Council of Arbitration annexure N1 minutes. That's an email minutes. Page number 186 is a registered post letter as well. Annexure N2 minutes. Basis the order of this honorable court minutes, we sought for appointment of an arbitrator. Enclosing the order of this honorable court minutes, the reply given minutes by ICA minutes will find it page 201. The acknowledgement, they asked us to give us claim statement in brief and pay minutes 37 rupees 1,000 of money. We paid that money as well minutes. And then minutes the option of minutes the respondent did not respond to minutes the notice invoking notice seeking appointment. Then minutes the in fact the ICA wrote an email minutes that minutes will find it page number 212 minutes. After back and forth minutes in January 2023, the appointing institution minutes wrote to say that the respondent has not given any reply to the notice for appointment of arbitrator. In the end minutes, they say that they have forfeited their right to nominate an arbitrator. Therefore, they say that we will notify both parties about the appointment of the sole arbitrator shortly. That's the end of the letter minutes at page number 212.
We will notify both the parties after appointment of sole arbitrator shortly.
Thereafter, my lords, the arbitration has not taken place. The appointment has not taken place. In fact, my lords, they write to us saying that they want to appoint, my lords, a learned, that High Court judge, my lords, based out of Delhi. We, my lords, responded to say that it's not convenient because the parties, my lords, are based out of Bangalore. The arbitration has to happen at the principal secretary's office in Bangalore, or my lords, in Bangalore, because the jurisdiction is at Bangalore. It would be inconvenient, my lords, to go to Delhi, my lords, for arbitration, or my lords, to bear the expenses of the arbitrator for his travel till here. In fact, my lords, the ICA's panel, my lords, has
Issue notice to the respondent.
may request one thing. Mr. T.P. Vivekananda Menas is on panel for the respondent. He may not have appeared on the last date. I mean,
All right, but not in this matter.
Minutes, a request for date. The reason is from 2020 minutes for invocation is
All right, sir. You want emergent notice, you take out emergent.
I'm grateful.
Returnable by 5th of July.
I'm grateful. 14 also
Both
same.
the matter,
There are two
yes.
Similar contract.
Yes.
Takes fresh address, minutes and furnish the fresh address of respondent number 3.
Fourth time. You have to furnish correct address.
Yes, I'll furnish the correct.
Finally, 2 weeks time is granted at the request of learned counsel for petitioner to furnish the correct address for service of notice and take steps in respect of respondent number 3. Yes.
In this matter, there is some office objection, Your Honor. Will comply the office objection to the date of hearing. Kindly 1 week time may be given. Over I mean.
Please serve a copy.
Yes, sir.
Please serve a copy. ಆಯ್ತು ಒಬ್ಬರು ಕೊಡ್ರಿ ನೆಕ್ಸ್ಟ್ ಆಮೇಲೆ ಮಾಡಿಸ್ಕೊಂಡು ಕೊಡ್ರಿ
Sure.
please collect it.
Sure.
It is only an application to recall the order of dismissal. Again, what is the matter about? What is the matter about? Learned counsel for the petitioner has served a copy of IAS number 1 and 2 of 2023 on the learned counsel for the respondents. Full stop. Next para. Order on IA number 1 and 2 of 2023. Full stop. These applications are filed for recalling the order dated 14th of September 2022 while seeking condonation of delay of 154 days in filing the application. Stop. Next para. Stated in the affidavit filed along with the application for condonation of delay that on 14th of September 2022, when this court passed the order, the learned counsel was on his legs in another court, and therefore, unfortunately, the learned counsel was not able to appear before this court. Full stop. If that is the case, the application for recall should have been filed immediately thereafter. Full stop. Although the reasons sought to be offered is not convincing, nevertheless, taking into consideration the dispute brought before this court, which touches upon the civil rights of the petitioner, this court is of the considered opinion that the delay may be condoned by imposing costs on the petitioner. Full stop. Next para. Consequently, cost of rupees 2,000 is imposed on the petitioner, which shall be payable to within a period of 1 week from today. Full stop. Delay is accordingly condoned and the application is allowed while recalling the order dated 14/9/2022. Full stop. The petition is restored to its original file. Full stop. Yes. List this matter for final hearing on 28th of June, next Wednesday. Yes. You are appearing for whom? Private respondent. That is the panchayat. Mugitalla innenu. Yen records. We will see. There is disputed questions of title that cannot be decided by the authorities. Yes. Special order. Land reforms matter. Huh? What are the objections? Date of death of respondent 3 is not shown. Number of days delay is not mentioned. A week's time is granted at the request of learned counsel for petitioner for complaints of the office objections raised on IAS number 123 of 2020.
I may be allowed to take fresh process in respect of respondent R4B to R4H.
Week's time is granted at the request of learned counsel for petitioner for taking fresh steps in respect of respondent number
R4B to
4 bracket B and H.
ಟೈಮ್ ಬೇಕಾಗಿತ್ತು ಆಗಿದೆ ಸ್ಕೆಚ್ ಎಲ್ಲ ಮಾಡಿ ಕೊಟ್ಟಿದ್ವಿ ನಾವು ಪ್ರಾಪರ್ಟಿ ಒಂದು ನೋಟ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ 2 weeks 4/7
At the joint request of the learned counsels, release this matter on
4/7 or any time up to
4th of July.
Was but a copy to the learned counsel to appear for the bank. As per the CH order,
the interest rate was reduced to 13%. It's only a flat rate. And I also made a representation for one-time settlement. Already I deposited about 7 lakh and odd back. And then the last later memo, the last representation, 19th April, 20th April memo filed on 20th April. In terms of that, I sought for OTS, one-time settlement, that I will make further payment of 10 lakh, not returning amount of 7 lakh and odd which I already paid. But they are saying it is 23 lakhs. The freedom of appears for the bank.
Dispose of the petition.
Page 20 only. Yes.
Allah, what are you asking in the memo?
I want to already I paid as per the earlier K80 order. Recalculate, I have to file it as according recalculate. I deposit the amount of 7 lakh 90. When by that time they brought the property for sale auction. Then this time court taking to note of the amount already deposited, paid the auction. Thereafter, I was asked to approach the authority by filing a representation, which I gave earlier. But since it was not considered as the last representation, I given on 11th April 2023, page number 20. With I'm making a request that let this representation be considered. 10 lakh is another 10 lakh I will pay. Under the OTS. Memo I filed on 20th April.
But why do you want the matter to be disposed of?
So in terms of that, I request that our pastor let him come our
Dispose madre, the benefit of the interim order of stay will go.
Then otherwise I will, if your lordship permit me, I will deposit another 10 lakh is Martin Becker. Page 20.
Marty, see, if you are not disputing it, why don't you go and deposit? Why do you want to ask the permission?
Now they are saying 35 lakhs. Earlier it was 14 lakh. Then 7 lakh I deposited. What is in this? That is the issue.
Correct. See, but if you are not disputing that you are in any way you are liable to pay more than 10 lakhs.
Yes, sir.
Why don't you go and deposit? You deposit madre, then they will also get some reason to consider your request.
Yes, sir.
Learned counsel for the petitioner
4 weeks I will deposit 10 lakh.
seeks leave of this court to permit the petitioner to deposit a sum of rupees 10 lakhs.
Other sum of 10.
With the first respondent, Apex Bank. So, the petitioner is permitted to do so, and the payment shall not in any way prejudice the case of the petitioner. Full stop. Yes. If such payment is made by the petitioner, the first respondent may reconsider the request made by the petitioner, including the one made on 11/4/2023. Yes.
For the petition. My lord, this is a matter wherein the public road was obstructed by the respondent 5 to 7, my lord. But after filing of this case, my lord, BBMP has cleared the encroachment. But my lord, my prayer is to maintain the road, my lord.
They have to.
Yes, my lord. My lord, on the basis of. Because he claimed ownership of the property, which is not adequate.
Sir, please don't take law into your hands. If there is any claim to be made, you please do it in accordance with law. You can't come and dump debris on the footpath or the road just because you are raising a claim. All that you do in accordance with law, sir, there is no difficulty. I will never. Purple. Yes.
No, my lord, there is no property, my lord. Allah, acquisition today. They have taken
ಏನಾದ್ರು ಇದ್ರೂನು, see, if it forms part of a road or a footpath, you will not be permitted to encroach upon it. That would amount to taking law into your hands. Yes, ಅಷ್ಟೇ. ಅದ್ ಬಿಟ್ರೆ ಏನು ಇಲ್ಲ. You, as and when you succeed, you can proceed and take possession of the property in accordance with law. Yes. ಅವ್ರು ಏನಾದ್ರು ಮಾಡಿರ್ಲಿ ಪ್ರೇಯರ್. No, we are not going to pass that kind of an order granting all the prayers that are made. We will only record your submission that since there is a complaint made and now the BBMP has stated on record that it has removed the debris that were put on the road, and the road is clear now. There is no difficulty for any person to make use of the road. It's a public road. Yes, purple. ಏನು objection? ಕೊಡಿ. Yes, yes. ಏನಂತ ಇದೆ ಎಂಟ್ರಿ ಮಾಡೋರು?
Copy to be. My lord, problem here is whatever the substance, whatever orders they have got, my lord, we don't want to get into that, my lord. Not only has they have lost the writ petition in this court challenging the acquisition, my lord, even they have sought for enhanced compensation. That also.
ಯಾವುದು? Where is that interim order?
Annexure
2018 ಏನಂತ? Shall not initiate any prescriptive action in respect of the land bearing number so and so measuring 1 acre 14 guntas. Is the next date of hearing. ಏನು prescriptive action ಅಂದ್ರೆ?
our land measuring 1 acre and 14 guntas. There is no possession taken. The restriction are also managed.
If it forms a part of the layout and you are in possession of a certain part of the layout and claiming rights over that property against BDA, you can continue to agitate before, but don't do anything on the footpath and road. ಅಷ್ಟೇ ನಾವು ಹೇಳ್ತಾರೆ. Yes, ಬರ್ಕೊಳ್ಳಿ.
Kindly see my prayer also, not asked anything that cannot be granted.
All right.
Ask for anything.
The petitioner had made complaints to the third respondent, Assistant Executive Engineer, Beniganahalli Ward, BBMP, and the station house officer of Banaswadi Police Station, alleging that respondents number 5 to 6, 5 to 7 are encroaching upon a public road and the footpath. More particularly, Fourth Cross Road of Chikkabanaswadi. Stop. During the course of these arguments, these proceedings, statement of objections have been filed at the hands of the contesting respondent. Stop. Learned counsel for the contesting respondents has drawn the attention of this court to an interim order dated 28th of December 2018, passed in WP number 53304 of 2018. Bracket LA-BDA. Close bracket, full stop. Next para. On going through the statement of objections filed at the hands of the contesting respondents, it is clear that the contesting respondents are agitating before this court the acquisition notification issued by the respondent state government. Full stop. The Bangalore Development Authority has formed the layout known as Old Madras Road, Banaswadi Road, practically OMBR layout, including the 1 acre and 14 guntas of land. One acre and 14 guntas of land in survey number 220/1 of Banaswadi village, in respect of which the claim is made by the contesting respondents. Full stop. Be that as it may, we are only concerned with the public road, footpaths formed by the Bangalore Development Authority and which is now in the control of the respondent BBMP. Full stop. Even if the contesting respondents are agitating before this court, their claim regarding the acquisition notification, nevertheless, the contesting respondents will not be permitted to encroach upon the public roads and footpaths. Stop. On the contrary, if such encroachment is found, the commissioner and the officers of the BBMP are authorized in law to take action to remove all such encroachments on public streets. Full stop. In that view of the matter, this this court, having taken note of the submissions made by the learned counsel for the contesting respondents, that all the debris that were put on the road and footpath have been cleared, and there is no such obstruction at this point of time, this petition stands disposed of, directing the respondents BBMP to ensure that no part of the public street, including the 4th crossroad at Banaswadi, is encroached upon by any person, including the contesting respondents herein. Full stop. No debris or building material shall be placed on the road or any part of the footpath. Full stop. Next para.
There is
No, every road will have a footpath. ಇಲ್ಲ ಅಂತಂದ್ರೆ ಪೂರ್ತಿ ರೋಡ್ ಆಗೋಗುತ್ತೆ. With these observations, the petition stands disposed of.
Subjection ಇದೆ.
ಏನ? Office objections raised on the wakalat filed on behalf of respondent number 4. Yes. Yes.
They have not filed any statement of objection. Kindly see, my lord.
Again, what is this matter about?
This is, my lord, original suit has been filed in the year of 2001.
my lord, seeking my lord declaration. Kindly see 194 page. This is two petitioners have filed my lord original suit. In OS number my lord 8707 of 2021, 8706 of 2021, and actually up starts from page 140. This is second round of litigation. Operative portion of the order, I'll make submission 194. Declare that, Siktaswami order. Declare that the suit schedule properties of the both cases are does not form a part of any civic community site, and defendant has no manner claim right title interest over the suit schedule property. It is further declared that the both plaintiff being the absolute owner in peaceful position enjoyment of the suit schedule property are entitled to transfer kata in their name in respect of the suit schedule property. It is directed the defendant authority by way of mandatory injunction transfer kata in the suit schedule properties in the name of the both plaintiff by way of collecting necessary charges prescribed under law. It is restrained the defendant, its man, agent, anybody claiming.
All right.
This is my lord, earlier occasion, my lord. I'll draw your lordships to regarding issue. Kindly, my lord, see the earlier occasion, Bangalore Development Authority.
Have you challenged this one?
ಇಲ್ಲ ಇದು ಸೂಟ್ ಆದ್ಮೇಲೆ ಇನ್ನು ನೋಟಿಸ್ ಬಂದಿಲ್ಲ ನಾವು ಕೇವೇ ಟಾಕಿಟ್ suit as well after lapse of 8 years. Now, my lord, it appears that they have filed. Look, officer Madlida in computer provided, my lord, from 2017. Earlier occasion, my lord, that they have challenged before this honorable court.
What do you want?
I want, my lord, since, my lord, there is a declaration, this honorable court in RFA directed the civil court to frame certain issue regarding, my lord, a declaration and whether BDA is entitled to civic community sites without, my lord, seeking surrender of the property. That is under 32 subclause 2 of the BDA Act. All these issues were framed and we have, my lord, tender evidence and the BDA has tender evidence. Ultimately, my lord, a decree came to be passed and from in the year of 2017 itself. And from up to 2023 till filing, my lord, immediately we have made an application for transfer of kata. Kata has not been transferred. And my lord, this has not been challenged. When we have issued, this honorable court issued notice. Now, my lord, the RFA came to be filed after lapse of 8 years. But other interim order illa. Hagagi, insofar as judgment and issues is concerned, my lord, already it is decided whether I am entitled or not. Therefore, my lord, I am seeking, my lord, direction. Kindly see
The BBMT.
To transfer. Yes, my lord. In the meanwhile, my lord, another prayer which we have sought is, my lord, the notification has been issued during the pendence when BDA, my lord, is contesting the matter before the civil court. On 15/4/2011. The respondent authority has passed notification. That is 15/4/2011 bearing so and so UD2 insofar as serial number 30 in part 4 of published in Karnataka Gazette notification dated 24/2000 as per Annex V published by the respondent. This is my lord notification. They have BBMP, even though BDA has not transferred the property. So moto BBA has declared us that notification has issued during the pendency of the, my lord, original suit to declare that that is a park, civic community site and park. Now we are in position that is vacant, all these things. Therefore, my lord, that we have challenged that also. If they have objection, my lord, let them file objection regarding this also. Then, my lord, the matter has to be heard. Otherwise, my lord, I'll argue on the merits.
How is it that you lost the case before the?
All these issues has been considered.
Now merely because it is pending and now you have filed it. Should it prevent the petitioners from seeking the registration of kata in their name? There is a specific direction given by the trial court. Why are you getting into all? Huh?
Based on that, we found the public at large will begin to survey. In the same property, they claim that they are the one. They find the suit. And substitute the same to
This, my lord, this, sorry.
Now they start
How does the BDA hand over the civic community by a notification?
My lord, can we see for a moment, my lord, inquiry number 154. And they should not make false submission before this court. All these issues, my lord, by virtue of direction issued by RFA, my lord, 70 of 2005. This honorable court directed them to frame following issues, and issues has been framed whether BDA has got rights over the without seeking release of the property by the layout, without getting approval, whether they can hand over the property to BBMP. All these issues were framed. There are several issues by virtue of direction that has been dealt with by the court.
Let them file objection.
Please.
Statement of objections will be filed at the hands of the respondents, BDA and BBMP within a period of 2 weeks from today.
My lord, one intelligence, my lord. Insofar as, my lord, the documents which is handing over what they have submitted. Since, my lord,
That should,
please,
that statement of objections contain all that information.
please, my lord.
Now,
Again,
why should we specifically say all those things?
please, but
Yes. Please, all right.
on the date, put it.
Yes.
Before.
My lords, there's been a bereavement in the family of my colleague, Mr. Banu Prakash. So I request your lordships to have it sometime in the next week, please. And the report will be filed in the due course, my lords.
Yeah, he is appearing for BBMP, is it?
Yes, my lords.
A submission is made on behalf of the respondent, a learned counsel for respondent BBMP, that there has been a bereavement in the family, and therefore the learned counsel is unable to appear today. Full stop. Release this matter on 28th of June for compliance of the directions issued on 7/6/2023.
Obliged, my lords.
And for the petitioner, I should invoice him permitted. I should invoice him.
Angala agadilla. Some alternative arrangement has to be made. Angala pudadilla no.
Obliged, my lords.
This is the matter on which I made brief submissions.
Yes, yes.
Now, having understood the mind of the honorable court, I am filing a memo on record the subsequent development which has happened after filing of the writ petition. And I must clarify to the honorable court that I am not seeking any adjudicatory relief in the hands of this honorable court, but for the fact that I have to bring it to the notice of lack of accountability on the part of the BBMP in playing with the civil rights of the parties. And I am not seeking a sentence from this honorable court. This BBMP, which is accountable, huge properties are involved. When they are involved, they cannot have an ad hoc mechanism of issuing a khata and thereafter taking a U-turn for good. I don't blame them for taking U-turn because it is that they acted illegally in issuing an endorsement in the name of a non-owner of the property, which resulted in execution of the sale deed. And after filing, this writ petition was filed on 6/4/2023, and maybe perhaps a good sense has prevailed upon them, and they have issued this endorsement stating the position that the property stands in the name of the 4 owners as on 30th May 2023. So my substantial grievance before this honorable court is redressed by virtue of this khata. Now the next question, coming back to the accountability of the BBMP, I wanted to bring you to the notice of this honorable court that what is under challenge is the endorsement. This only, I am only for the purpose of making this submission only to show my bona fides.
Now anyway, the kata has been made out in your name.
ಅಲ್ಲ ಅವ್ರು ಯಾವತ್ತು ನಮ್ಮ ಹತ್ರನೇ ಇತ್ತು ಅದ್ ಏನ್ ಮಾಡಿದ್ರು ಅಂದ್ರೆ ಮಿಸ್ಚಿವಸ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಪೇಜ್ ನಂಬರ್ 190
ಎಲ್ಲ ಒಂದ್ಸರಿ ಬೇರೆ ಹೆಸರು ಬಂದ್ಬಿಟ್ಟಿದೆ.
ಇಲ್ಲ ಬೇರೆ ಬರ್ಲಿಲ್ಲ ಅದು ಎಲ್ಲ ನಾವು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ಮೇಲೆ BBMP is very hesitant to face this honorable court. Not that they can face me, but they have to face the honorable court for their illegal activity. 190 ತಾವು just 190 ಪೇಜ್ ನಂಬರ್ 190 ತಮ್ಮ ಗಮನಕ್ಕೆ ತರ್ತೇನೆ ನಾನು. ಯಾವ ತರ ಮಿಸ್ಚೀಫ್ ಆಗುತ್ತೆ, ಕೋಟ್ಯಾಂತರ ರೂಪಾಯಿ ಪ್ರಾಪರ್ಟಿ, you sub-registrar khata certificate, even though it is not a title document, all concerned will act upon it. ಈ 190 ಎಲ್ಲೇ ಮಿಸ್ಚೀಫ್ ಆಗಿತ್ತು. 23/12/2022ಕ್ಕೆ ನಾನು ಮೊನ್ನೆ ಓದ್ದೆ ಅದನ್ನ, ಸ್ವತ್ತಿನ ಅಳತೆ ಈ ಮಲ್ಲೇಶ್ವರಂ ARO ಇದನ್ನ ಕೊಡ್ತಾರೆ. ನಮ್ಮ ಇದು ಕನ್ಸರ್ನ್ ARO ಹೊಂಬೇಗೌಡ ನಗರ್ನವರು ನಮ್ಮ ಖಾತಾ ಇಂಟ್ಯಾಕ್ಟ್ ಇದೆ ಈಗ 30th May 2023 ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇಂದ. ಆದ್ರಿಂದ ನನಗೇನು ಗ್ರೀವೆನ್ಸ್ ಇಲ್ಲ. ಆದ್ರೆ ಡ್ಯಾಮೇಜ್ ಇಸ್ ಆಲ್ರೆಡಿ ಡನ್ ಆಸ್ ಎ ರಿಸಲ್ಟ್ ಆಫ್ ಅನೆಕ್ಸ್ಚರ್ K at ಪೇಜ್ ನಂಬರ್ 190. ತಾವು ಅದನ್ನ ನೋಡಿದ್ರೆ ಮಲ್ಲೇಶ್ವರಂ ಉಪವಿಭಾಗದವರು ಕೊಡ್ತಾರೆ. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಸುಮಾರು ದಿನಗಳಿಂದ ಸಾಫ್ಟ್ವೇರ್ ಪ್ರಾಬ್ಲಮ್ ಇಂದಾಗಿ ಸಾರ್ವಜನಿಕ ಖಾತಾ ನಕಲು ಹಾಗೂ ದೃಢೀಕರಣ ಪತ್ರ ನೀಡಲು ಲಭ್ಯವಿಲ್ಲದಿರುವುದರಿಂದ ಎಲ್ಲಾ ಸಹಾಯಕ ಕಂದಾಯ ಅಧಿಕಾರಿಗಳು ತಾತ್ಕಾಲಿಕವಾಗಿ ತಮ್ಮ ಕಚೇರಿಗಳಿಗೆ ಸಾರ್ವಜನಿಕರಿಗೆ ಅನುಕೂಲವಾಗುವಂತೆ ಸಾರ್ವಜನಿಕರು ನೀಡುವಂತ ಅರ್ಜಿಯನ್ನು ಸ್ವೀಕರಿಸಿ.
ಓದಿದ್ರಿ ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ ಓದಿದ್ರಿ, ಬಟ್ ನೌ ಯು ಆರ್ ಪಾಯಿಂಟಿಂಗ್ ಔಟ್ ದಟ್ ಸಮ್ ಅನ್ಕನ್ಸರ್ನ್ಡ್ assistant executive engineer has given this endorsement.
Yes.
He is not concerned with the property at Hombegowda Nagar.
ಅಲ್ಲ ಅವ್ರು ವೆರಿಫೈ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ರು. ವೆರಿಫೈ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದಾಗ ಇಲ್ಲಿ ಅದನ್ನ ಹೇಳ್ತಾರೆ.
How could he do this?
He has done it. That's how what made us to come to this honorable court. But for the interim order passed.
And what efficacy would this endorsement have?
It resulted in execution of the sale deed in the next page.
That type of acceptance of this endorsement would not be permissible.
ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರು.
ಮಾಡಿದ್ರೆ see, then you will have to take action in accordance with law. You know very well the documents that are required is the kata certificate, kata extract.
ಹೌದು.
On the basis of this endorsement.
ನಮ್ಗೆ ಅಷ್ಟೇ ತಾವು ಹೇಳಿದಂತೆನೆ ಇದು ಆಗೋಗಿದೆ. ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅನೆಕ್ಸ್ಚರ್ ಎಲ್ಲಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಈ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ತಗೊಂಡು ರಫೀಕ್ ಅವರು
have a good case anyway.
ಅಲ್ಲ ನನ್ ಗುಡ್ ಕೇಸ್ ಇರುತ್ತೆ, ಬಟ್ I have to avoid this document based on what say the council will have before this honorable court. You have to set the house in fire and let everybody get burnt in the house. I remain outside ಅಂತ ಆಗಿದೆ ಈಗ BBMP ಅವರು. ಅವರು ಈ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಡುವಾಗ ಅವ್ರಿಗೆ ಕನಿಷ್ಠ ಜವಾಬ್ದಾರಿನ ಅವ್ರು ನಿರ್ವಹಿಸಲಿಲ್ಲ.
I am sure they'll definitely come and say we have not issued this.
ಇಲ್ಲ ಅಲ್ಲ ಅದನ್ನ ಹೇಳಕ್ ಆಗಲ್ಲ.
They will definitely come and say this.
ಅಲ್ಲ ಅದನ್ನ ಸ್ವಲ್ಪ ತಾವು ಅವ್ರು ಕೇಳ್ತೀರ, ತಾವು ಕೇಳಿದ್ರೆ.
First of all, it is issued by a person who has no jurisdiction. So it is easy for them to say, ನೋಡಿ ಸ್ವಾಮಿ
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ
ಮಾಡೋದಲ್ಲ, ಯಾವ್ದೋ ಬೇರೆಯವ್ರದ್ದು ಅಂತ ತೋರಿಸಿದ್ದಾರೆ, ನಾನು ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರ.
ಅಲ್ಲ ಈ ವಿಚಾರದಲ್ಲಿ ನಾನು ಅದನ್ನ ಜಾಸ್ತಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಆದ್ರೆ ಕಾನ್ಸಿಕ್ವೆನ್ಸಸ್ ಆಫ್ ಲ್ಯಾಕ್ ಆಫ್ ಪಬ್ಲಿಕ್ ಅಕೌಂಟಬಿಲಿಟಿ ಹ್ಯಾಸ್ ಟು ಬಿ ಗಾನ್ ಇನ್ ಟು. ನಾನು ಸಿವಿಲ್ ರೈಟ್ಸ್ ತಮ್ಮಿಂದ ಏನು ಕೇಳಲ್ಲ. ನಾನು I have to avoid this.
All these issues will be considered by the civil court.
ಹಾಗಾದ್ರೆ ನನ್ನ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಡಿಸ್ಪೋಸಲ್ ಮಾಡುವವರೆಗೂ ಅದಕ್ಕೆ ನಾನು ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ನನ್ನ ಮೆಮೋನಲ್ಲಿ ನಾನು ಕೇಳಿದ್ದೇನೆ.
ಮಾಡೇ ಬಿಟ್ಟಿದ್ರಲ್ಲ, ನಿಮ್ಮ ಹೆಸರಿಗೆ ಖಾತಾ ಇದೆಯಲ್ಲ, ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಏನು?
ಅಲ್ಲ ಖಾತಾ ಆದ್ರೆ ಇದು ಫರ್ದರ್ ಈ ಸೇಲ್ ಡೀಡ್ ಮೇಲೆ ಅವ್ರ ಖಾತಾ ಕೇಳಿದಾಗ ನನಗೊಂದು ಅಪರ್ಚುನಿಟಿ ಕೊಡಿ ಸರ್. ಈ ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆಯಲ್ಲ ಬೇಸ್ಡ್ ಆನ್ ಎ ಫೇಕ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್, Rahmatullah Khan, who is the R9, has obtained the sale deed. Now he will go to BBMP, seek transfer of khata. So that inquiry I may be given.
You are entitled in law to raise an objection.
ಮಾಡಿದೆ.
They are also liable or duty bound to consider your objection.
Sir, ನಲ್ಲಿ ನಾನು ಕೊಟ್ಟಿದ್ದೇನೆ 208 ಅಲ್ಲಿ ಅದರ ಅಷ್ಟು ಅಬ್ಸರ್ವೇಷನ್ ಆದ್ರೆ, but at the same time what I am dissatisfied to the extent that the BBMP is going scot free in spite of indulging in the mischief.
No. All those things will come to light only after a full dressed trial.
ಅಲ್ಲ 226 227 ತಾವು ಡಿಸಿಪ್ಲಿನ್ ಮಾಡಬಹುದು ಅವ್ರನ್ನ, ಒಂದು ಡಿಸಿಪ್ಲಿನ್ ಮಾಡಬಹುದು.
See, they will definitely say this is not issued by our officer. I am very sure.
ಅಲ್ಲ ಹೇಳಿದ್ರೆ ನನಗೆ ಉಪಯೋಗ ಆಗುತ್ತೆ. ಫ್ರಾಡ್ ಪ್ರೂವ್ ಮಾಡಿ
ಹಂಗೆ ಮಾಡ್ಬೇಕು ಅವ್ರು, ಇಲ್ದಿದ್ರೆ
Yes, ma'am.
Sir, why would a officer of the Malleshwaram range issue this kind of an endorsement
To sub
in
register.
respect of a property which doesn't come under his jurisdiction?
ನಮ್ಗೆ ಆಶ್ಚರ್ಯ ಆಯ್ತು ಅದು.
They will definitely say non issue ಮಾಡಿಲ್ಲ ಅಂತ.
Direct petition be disposed. My lord may consider a limited interim relief till the representation is considered. Otherwise, they play havoc and make me come again before this honorable.
We will direct them to consider your objections and
Till
pass
then.
orders.
Till then, some relief. Otherwise,
You have already filed objections, sir.
money.
Without considering your objections, they can't pass orders.
I am greatly obliged.
The petitioner being aggrieved of the impugned endorsement dated 23/12/2022 at Annexure K is before this court. Stop. Next. Learned Senior Counsel Sri D.V. Shankar Narayan Rao, appearing for the petitioner, submits that although the petitioner is the owner of the property in question,
Petition along with three.
Huh?
Petition along with three others.
along with the three others, is the owner of the property in question, which is situated at
We go down. It's exactly the schedule at page number 17. Wilson Garden and Tanapate. Nagar, Wilson Garden, Bangalore 27. Schedule property which is described.
New municipal number 22, old site number 282, having property identification number PID number 62-115-22, measuring 80 into 47 feet, measuring about 80 into 47, measuring about 4,240 square feet, situated at 5th Main Road, 11th Cross, 36th Division, Hombegowda Nagara, Wilson Garden.
Shankar Rao appearing for the petition submits a call to petitioner along with three others are the owners of the property in question, which is situated.
The impugned endorsement, and they were registered as the khatedars in the office of the respondent BBMP. Nevertheless, by virtue of the impugned endorsement, Annexure K, dated 23/12/2022, said to have been issued by the Assistant Executive Engineer,
Assistant Revenue Officer,
Malleshwaram Subdivision, BBMP. The name of respondent number 3, M. Abdul Rafiq, is shown as the owner of the property. Stop. Learned Senior Counsel submits that as per the endorsement, it appears that the applications which were pending consideration for change of kata were required to be considered in view of a software problem, and consequently a direction was issued that by a handwritten entry, the name of the third respondent is shown as the owner of the property. Stop. Learned Senior Counsel submits that the contesting respondents have taken advantage of the impugned endorsement and have proceeded to execute a sale deed.
Sale deed is executed by R9 at 191. R3 in favor of R9. Sorry, 191 annexurial.
And senior counsel submits that the contesting respondents have taken advantage of the improved endorsement and have proceeded to execute the sale deed.
Dated 7/1/2023 at Annexure L. Stop. The third respondent, M. Abdul Rafiq, is said to have sold the property in question in favor of one Shri K. Rahmatullah Khan,
R9.
who is respondent number 9 hearing. Stop. Learned Senior Counsel submits that it is evident from the material available on record that the third respondent, M. Abdul Rafiq, who had no manner of right, title, or interest, has executed a sale deed in favor of the ninth respondent. Stop. Consequent to the execution of the sale deed, the ninth respondent has approached the.
It's not on record. They have not approached.
Huh?
It's not on record. We are not based on record that they have approached.
But ಏನು objections file ಮಾಡಿದ್ದೀರಾ?
Now objection ಈ ಒಂದು illegal endorsement ಗೆನೆ ಮಾಡಿದ್ದು at annexurial, or it could be there. Yes, ma'am.
Consequent to the execution of the sale deed,
I'm sorry.
respondent number 9 appears to have approached the competent authority
Respondent to
seeking change of kata in his name. Stop. The petitioner, along with the other owners, have already filed their objections before the authority. Full stop.
annexurial. My lord may say the
Learned Senior Counsel would therefore submit, Learned Counsel would further submit that after the writ petition was filed, the respondent assistant executive engineer, the second respondent assistant revenue officer, Ombegoda Nagara, BPMP, has once again issued a kata certificate showing the name of the petitioner and three others. Full stop. To that extent, the grievance of the petitioner is redressed to some extent. Full stop. Nevertheless, it is the apprehension of the petitioner that consequent to the execution of the illegal sale deed, the ninth respondent would press for transfer of kata in his name. Stop. The Learned Senior Counsel would therefore submit that a direction should be issued to the respondent, second respondent, assistant revenue officer, Ombegoda Nagara subdivision, BBMP, to consider the objections already filed by the petitioner or which may be permitted to be filed once again, and without considering the objections, the request made by the ninth respondent for transfer of kata should not be considered. Full stop. Next para. You are appearing for whom?
Whether they will transfer or they cannot go away, say, they have any period competency, so there's the same. It is illegal.
No, but the khatedar, earlier khatedar, appears before the officer and says, look here, in your records, I am the owner of the property. I have not executed the sale deed, and therefore you should take note of my objection and inform the applicant that an objection has been raised and therefore there's a dispute of title, go before the civil court. You don't do anything. The BBMP should not decide anything. Isn't it? Barkal. Per contra, learned counsel for the 9th respondent submits that in terms of section 149 of the BBMP Act, 2020,
Just title holder.
whenever the title of the property is transferred by way of a registered instrument, the purchaser has a right to approach the BBMP and seek transfer of kata in his name. Full stop. Next para. Having heard the learned senior counsel for the petitioner, the learned counsel for the contestant respond number 9, and on perusing the petition papers, this court finds that there appears to be a dispute of title. Stop. Nevertheless, going by the provisions contained in section 149 of the Act, it does not preclude the second respondent assistant revenue officer to consider the objections that could be filed by the petitioner before considering the application for transfer of kata at the hands of the 9th respondent. Stop. If it is clear from the records of the BBMP that the petitioner along with 3 others were the previous katedars and they have not executed the sale deed in favor of the 9th respondent, then the second respondent, assistant revenue officer, may issue an endorsement to the 9th respondent, taking note of the objections raised at the hands of the petitioner and direct the parties to approach a competent civil court to get a declaration of title. Full stop. At any rate, the second respondent, assistant revenue officer, shall not decide the disputed question of title. Stop. Next paragraph. With these observations, the writ petition stands disposed.
My lord, say the representation is at annexure N at 63216.
I'm you are actually not very clear whether that objections is in respect of an application for transfer of kata, or you had already filed the objections regarding that endorsement.
Transfer of kata, I stand corrected. Now note the annexure N and the page number 208 ಅಲ್ಲಿ ಅದು transfer of kata. Clarify. Maybe I was trying to avoid a devil, but now I have to face the devil. 208. 208 ಅಲ್ಲಿ ನಾನು ಹೇಳಿದ್ದೇನೆ. Objection to the transfer of kata.
Objections
in the name of Rahmatullah Khan.
Objections dated 6/3/2023 at annexure N.
Yes, I'm really obliged.
Each man. The grievances, Lord, annexure A to D are representation given to the revenue authorities on the ground that
Office objections ಇದೆ. You were not paid the court fee. ಯಾವಾಗ?
A ಆಗಿದೆ. Complaint ಮಾಡಿದ್ರೆ
ಯಾವಾಗ?
ಆಗಿದೆ ಅಂತೆ.
ಯಾವಾಗ? This notice put up yesterday, 20th.
ಅಂದ್ರೆ ಅವರು ವೆರಿಫೈ ಮಾಡ್ದಂಗೆ
Of course, yeah.
ಅಪ್ಲೈ ಆಗಿದೆ ಇದು ಪೇಜ್ ನೆಕ್ಸ್ಟ್ ಎಲ್ಲ ಚೇಂಜ್ ಮಾಡಿ ಸ್ಟಿಚ್ ಮಾಡಿದೆ
ಯಾವಾಗ್ರಿ ಹಂಗಿದ್ದಿದ್ರೆ ಅವರು ದೇ ವುಡ್ ಹ್ಯಾವ್ ರಿಟರ್ನ್ ಆಯ್ತು ಇಟ್ ಹಸ್ ಬಿನ್ ಕಂಪ್ಲೇಂಟ್ ಅಂದ್ಬಿಟ್ಟು ಇಟ್ ವಿಲ್ ನಾಟ್ ಬಿ ಲಿಸ್ಟೆಡ್ ಫಾರ್ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್.
ನೋಡಿದ್ರೆ ಅಪ್ಲೈ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಆಫೀಸ್ ನೋಟ್ ಮಾಡಲ್ಲ ಕೆಲಸ.
It will done 1/6/2023. Illappa, they have noticed that one and they have again said, no, list it before the court.
ಅಲ್ಲ ಏನ್ ಮತ್ತೆ ಅಬ್ಜೆಕ್ಷನ್
You please go and verify that.
That my grievance is,
Hmm.
but in respect of the property, Lord, the fifth respondent, Lord, who is constructing the building, Lord, without obtaining the license. The authorities have also issued an endorsement to the effect that, Lord, the no permission or license is granted. Kindly see, Lord, page 224, annexure M, this is by the panchayat, and annexure N and O are the issued by the revenue officers. To the effect that, Lord, the no permission is obtained. In spite of it, Lord, when I made a representation, they are not taking any action.
Learned AGA takes notice for response number 1 to 3.
Please,
Issue notice. Tagatirandre. Learned Counsel Shri MS Devaraj, who is present in the court, takes notice for response number 4. Gram Panchayat.
please. Please to the,
Issue emergent notice to respond number 5,
please.
returnable by 5th of July. Full stop. Learned Counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on Learned Counsel for respond number 4 and a copy on the Learned AGA. In the meanwhile, office objection shall be complied.
We will.
Is appear for the petitioner. This course order to hand summons to the respond number 4 and 5 minor. The respond number 4 and 5 refuse the hand summons.
Ellide
File the affidavit. Then acknowledgement article and the acknowledgement.
sorry, refuse amele there is no need for acknowledgement. Refused ಅಂತಂದ್ರೆ they have not received. ಮತ್ತೆ ಏನು ಮಾಡೋದು?
Writ of mandamus, my lord.
Huh?
Writ of mandamus. Election petition pending is 7/2/2022 in the petitioner evidence is completed. Only drag on the proceeding, my lord. Direct the dispose the petition. This is only the next month ಅಲ್ಲಿ ಎಲ್ಲ president election ಇಟ್ಕೊಂಡಿಲ್ಲ. ಅಷ್ಟರೊಳಗೆ ನಮ್ದು
ಅಲ್ರಿ ನೋಟಿಸ್ ಹೋಗಿದೆ ತಾನೆ?
emergency notice.
ಹೋಗಿದೆ, let it come then. This is matter of the service of release this matter 28th of June 2023. Awaiting the notice sent to response number 4 and 5. Yes. Huh? Learned Counsel Sri. Name, sir. N. Nikhil. D. Kamath. You already filed wakalat. Has submits that he has filed wakalat for response number 4 and undertake to file wakalat for response number 5. Full stop. Next para. However, learned counsel for the respondent BBMP. ಇದನಾ ಅಲ್ಲ has filed a memo dated 20th of June 2023 along with copy of a show cause notice dated 19/6/2023 issued under section 313 of the BBMP Act, 2020, calling upon respondents number 4 and 5 to explain as to why action should not be initiated against them for removing the deviated portion which has been constructed in violation of the sanction plan and the building bylaws of the BBMP. Stop. Learned counsel would therefore submit that 7 days time have been given to the answering respondents to explain as to why action should not be taken against them. Full stop. The further process will be taken up in accordance with law, and if it is found that respondents number 4 and 5 have put up construction in contravention of the sanction plan and the building bylaws, action will be taken to remove the deviated portion. Full stop. Next para. In view of the action taken by the respondent BBMP, the prayer made in the writ petition would not survive for consideration. Full stop. Next para. Accordingly, the writ petition stands disposed of with the direction to the respondent BBMP to proceed in accordance with law and take the proceedings to its logical ends. Full stop. At any rate, the action shall be concluded as expeditiously as possible, and at any rate within a period of 3 months from the date of receipt of a copy of this order.
Production of documentation.
That is the starting point. Everything has to be concluded within a period of 3 months. Yes. ತ್ರಿವಿಕ್ರಮ್ ಅದೇ ಅದು ಇನ್ನೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡಿದ್ರಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನ್ ಪ್ರೇಯರ್ ಡಿಫರೆಂಟ್ ಪೀರಿಯಡ್ ಕೊಡಿ. Learned counsel Sri M.B. Chandrachuda, appearing for respondent number 8, the Udigere Gram Panchayat submits that the petitioner had filed another writ petition in WP number 5463 of 2023 in respect of the previous period, making similar allegation that the respondent Gram Panchayat has been collecting parking charges and has established shops within the premises of the of Sri Bhogalakshmi Narasimha Swami Temple, Devarayana Durga, which is a Mujrai institution. Stop. This court, by order dated 13th of June 2023, held that the assistant commissioner was called upon to file a report, and in terms of the report, it was found that the road in question and the property in question, where the parking charges and shops have been established, parking area and the shops have been established, belong to the respondent Gram Panchayat and not the Mujra institution. Full stop. Learned Counsel submits that in the present writ petition, the petitioner has raised similar grievance in respect of the subsequent period, and therefore the writ petition has to be dismissed on the same grounds. Stop. Next para. This court has gone through the earlier order dated 13th of June 2023 in WP number 5463 of 2023. Stop. It was found that the property indeed belongs to the respondent Gram Panchayat, and therefore the Gram Panchayat was entitled to establish shops in accordance with law and collect the rentals and collect the parking charges from the vehicles which were parked in the area belonging to the Gram Panchayat. Stop. Next para. Consequently, the writ petition stands dismissed. Huh? ಅದಲ್ಲ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಇದರಲ್ಲಿ ನೋಟ್ ಶೀಟ್ ಇನ್ ಬರ್ಕೊಳ್ಳಿ. Learned Counsel Sri MP Chandrachuda has filed a fresh wakalat on behalf of respondent number 8. List number 2 ಮಿಕ್ಕಿದ ಯಾವುದೂ ಇಲ್ಲ, ಓನ್ಲಿ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಮಾತ್ರ ಹೇಳಿದ್ ನಾನು. ಮಿಕ್ಕಿದೆಲ್ಲ ಇಟ್ ಎಲ್ಲೆಲ್ಲಿ ಇಂಟ್ರಿ ಮಾಡಲ್ಸ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಬೇಕು ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬಿಡಿ. ಮತ್ತೆ ಕರೀರಿ.
Number 2. Number 2.
Regarding the service proceedings, challenging section 14 order.
Yes.
Challenging the section 14 order, Your Honor. They may take the physical portion of the property.
Huh?
Bank, the respondent bank may take physical portion of property at any time, Your Honor. That's the reason I find this one.
Yes.
I am ready to pay the money, Your Honor. I need some 6 weeks time. So 2 installments I'll pay them. The amount is 1 crore.
This is in fact a cooperative societies matter. It should have come before this court only. How is it that it has gone before that court? Cooperative societies is a classification which should have been given to this writ petition, because the respondent is the cooperative bank.
It's Mahila cooperative.
Then why did you give the classification as GM?
All cases will come like that.
What all the cases will come like that only? Cooperative societies collected action ತಗೊಂಡಿರೋದು under the Cooperative Societies Act.
Loan amount is 1 crore 7 lakhs.
Ah.
And it's 2 installments, in 6 weeks, I'll pay the money. So I'm asking not to take.
What is the award? Where is the award?
They are gone on the surface proceedings, Your Honor, not on the,
Illama surface proceedings.
section 14 ಮೇಲೆ ಹೋಗಿದ್ದಾರೆ.
Huh?
Question notice ಕೊಟ್ಟು section 14 ಮೇಲೆ ಹೋಗ್ತಾರೆ. They have given the question notice. Cooperative Society Act ಮೇಲೆ ಹೋಗ್ಲಿಲ್ಲ ಸರ್. Paper publication ಕೊಟ್ಟು surface proceedings ಮೇಲೆ section 14 order ತಗೊಂಡಾರೆ. Not gone on the.
Yes, that is for taking possession.
Yes.
Howದು? Why should we stay this?
No, otherwise they'll come and lock the door.
Howದು? They are entitled to proceed in accordance with law, madam. What answer do you have?
I'm ready to pay the payment. Your
Then
Honor.
you should have paid it then. I am ready to pay ಅಂತ ಹೇಳಿ ಏನು, what is the use?
I need
Huh?
1 week time, Your Honor. 1 month's time, Your Honor. Please, otherwise tomorrow only they'll come and please.
What is the demanded amount?
1 crore 7 lakhs.
ಮತ್ತೆ how much are you going to pay now?
20% ಕೊಡ್ತಾರೆ some 2 weeks time. 1 month's time, 20%. Because he is in under tremendous, he is has got some.
ಎಲ್ಲ ಹಿಂಗೆ ಹೇಳಿ ಶಾರ್ಟ್ ಇದು ತಗೋತೀರಾ, ಆಮೇಲೆ you don't pay.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ನಿಗೆ
That is what we have been seeing.
2 weeks time, 1 month's time, Your Honor, please.
Where is the description of the property? Where is the description of the property? Real property, page number 7.
Page number 16 ಇದೆ.
Residential immovable property bearing corporation number so and so. ಏನಿದೆ vacant site ಇದು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಜನ ಇದ್ದಾರೆ. Tenants are staying in this property.
Huh?
Tenants are staying in this property. What tenants are there? But otherwise anytime they will come and lock the house.
ಹೌದಮ್ಮ. See, they have come to this level only after issuing notice to you, giving you time. ಅಷ್ಟೆಲ್ಲ ಆದ್ರೂ you are not paid. What can we do?
You are ready to pay on just 1 month's time.
ಈ ರೆಡಿ ಟು ಪೇ ಅನ್ನೋ ಬದಲು ಅಲ್ಲಿ ಹೋಗಿ ಪೇಮೆಂಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಈ ಕೆಲಸನೇ ಬರ್ತಿರ್ಲಿಲ್ವಲ್ಲ.
ತೊಳಗ ಸ್ವಾಮಿ, ಇಲ್ಲಿ ತೋಟ ತಗೊಂಬಾ ಅಂತ ಹೇಳ್ತಾರೆ. Otherwise we are not bound for any payment.
ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದಾಗ in terms of the no possession notice ಗಿನ ಮುಂಚೆ
Demand notice.
ಡಿಮಾಂಡ್ ನೋಟಿಸ್ ಕೊಟ್ಟಾಗ ಏನ್ ಮಾಡಿದ್ರಿ ನೀವು?
Had
Huh?
problem with some and the medical problems.
Where I have stated that there is a and there are tenants.
ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ, but schedule ಅಷ್ಟೇ ಹಾಕಿ.
ಶೆಡ್ಯೂಲ್ ಅಲ್ಲೂ ಇಲ್ವಲ್ಲ.
Total single building.
ಎಲ್ಲಿದೆ? Where have you stated? It looks like a vacant site.
Oh, yeah. Have given as per the section 14 order. 14 order ಅಲ್ಲಿ ಹಂಗೆ ಹಾಕಿದ್ದಾರೆ.
ಇಲ್ಲಿದೆ ಅಲ್ಲ, ಅದರಲ್ಲೂ ಪಾಯಿಂಟ್ ಮಾಡಿ at least. Please point out from that.
Page number 12. They have given the schedule.
Page number?
Page number 12. They have given the schedule of the house.
ಅದೇನೆ.
ಅಷ್ಟೇ ಅವ್ರು ಕೊಟ್ಟಿರೋದು. On section 14 order.
ಅಲ್ಲ, ಅವ್ರದ್ದೇನಾರು ಇರ್ಲಮ್ಮ. Where have you stated in your petition? See, if you want to make out some urgency, it should come in the petition. For the first time you are saying, no, there is a residential building, there are tenants and butto. Is it not a ground for you to have been stated? ಬರ್ಕೊಳ್ಳಿ. Issue emergent notice to the respondent returnable by Huh? Learned Counsel Shri Ram Bhatt K has entered appearance for the respondent by filing a caveat petition. Full stop. However, there is no representation for Idira. Mr. Ram Bhatt.
Okay, Ram Bhatt for caveat respondent.
There is no representation for the respondents. Full stop. Next para. Learned Counsel for the petitioner submits that there is a residential building in the scheduled property, and there are 4 tenants residing in the 4 tenements of the building. Stop. Learned Counsel submits that if a short accommodation is given, the petitioner will deposit the demanded amount along with interest. However, interim protection may be given to the petitioner and the tenants. If not, the tenants will be pulled out of the premises. Full stop. Next para. Consequently, the respondent bank is directed not to take any precipitative action consequent to the impugned order dated 18/3/2022 at Annexure B passed by the 31st Additional Chief Metropolitan Magistrate, Bangalore City, till the next date of hearing, subject to the petitioner depositing 20% of the amount demanded with the respondent bank within a period of 2 weeks from today. Stop. Thereafter, another installment of 20% shall be paid within a period of 1 month from the date when the period for the first installment expires. Full stop. If the directions issued by this court are not complied, the relief given to the petitioner shall stand automatically withdrawn. Full stop. Yes. Idonu same residential building,
And they have given 7 days notice, the notice will expire today on 14 days. 14 days, what they get expire on.
Yes, same order. ಅದರಲ್ಲಿ learned counsel Shri Ram Bhatt K is requested to take notice for the respondent.
This is another bank, not the same bank. This is.
ಅದೇ ಬ್ಯಾಂಕ್ ಅಲ್ವಾ? ಬೇರೆ ಬ್ಯಾಂಕ್. Issue emergent notice to the respondent bank. ಮಿಕ್ಕಿದೆಲ್ಲ ಸೇಮ್.
ಮಹೇಶ್ ಚೌಧರಿ
ಅಲ್ಲಿ ಅನಕ್ಷರ ಬಿ ಅಲ್ಲ ಅಂತ ಕಾಣುತ್ತೆ. ಅನಕ್ಷರ ಎ ಇರ್ಬೇಕು ನೋಡಿ. ಇದ್ರಲ್ಲಿ ಅನಕ್ಷರ ಏನಾ? Annexure A, dated,
31/5. Order dated 31/5.
all right. Yes,
Number 4, A Mahesh Chaudhary.
next.
Number 1,
ಅಲ್ರಿ 5 ಇದೆ ನೋಡ್ರಿ, ಅದನ್ನ ಕರೀರಿ.
5, petition.
Huh.
That is pertains to pro rata charges.
Huh?
Pro rata charges, demand notice issued by the respondent, annexure C, Malad. Identical matter as entry matter granted by the Supreme Court, Malad. Annexure F, Malad. Annexure C is the demand notice, Malad. Annexure F, identical matter, number of petition has been granted with commence from 58, page 58. Order portion 60, Malad. Pro rata charges and BCC charges only stayed.
Learned AGA takes notice for respondent number 3. Learned counsel Shri BL Sanjeev is requested to take notice for response number 1 and 2. Learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned counsel for the respondent BWSSB and a copy on the learned AGA. We'll stop. Next para. Since interim orders of stay have been passed in many such writ petitions, including WP number 11201 of 2020, there shall be an ad interim order of stay of the impugned demand notice at annexure C. Insofar as it pertains to advance probable pro rata charges and towards beneficiary capital contribution. Full stop. However, petitioner shall pay the prescribed fee for issuance of no objection certificate as indicated in the impugned demand notice, subject to which number 1 and 2 shall issue no objection certificate to the petitioner. Full stop.
Number 1. Interlocutor application, number 30. AYIM.
Lordship, I am appearing on behalf of the petitioner in item number 30, Your Lordship. I am praying for 1 week's adjournment in this matter as the senior counsel is appearing before Odisha High Court. Today is the reopening day of the Odisha High Court, Your Lordship. A 1 week time may kindly be granted. On 27th or 28th of June, Your Lordship, whichever is convenient.
Objection. What is this?
This is pertaining to the
14-2 petition, Your Lordship.
arbitration proceedings. Petitioner has prepared an application under section 14 of the program.
Yeah, there was an order appointing an arbitrator.
The main matter, which is the CAT of 2020, this honorable court had given a direction and they had also recognized an arbitrator.
Correct.
Subsequently, the arbitration proceedings had begun and the stage was set for the cross-examination of the respondent. At the time of starting the cross-examination, the petitioner tendered a memo directly to the honorable arbitrator telling that he is biased and he is capable of the respondent. Hence, the arbitration proceeding to be continued. So, after that, subsequently, the approach this honorable court under the petition.
And the proceedings are not going on?
Well, the proceeding, there is no stay as well.
All right.
Proceeding is going.
At the request of the learned counsel for petitioner, release this matter on 28th of June.
Much obliged, your lordship.
If it is going on, let it go on.
Yes, sir.
Yes.
31. That petitioner is died on loss of bail for filing the application for LR application. It is filing an abatement application.
Hundred and 78 days.
Yes.
Purpose. Odd on IAS number 123 of 2023. These applications are filed by the legal representatives of the sole deceased petitioner. To come on record as the legal representatives. So there is a delay of 178 days in filing the application. So learned counsel for the respondents fairly submits that the application may be allowed. Full stop. Consequently, delay is condoned, abatement is set aside, and the applicants are permitted to come on record as the legal representatives of the sole deceased petitioner. Stop. Next para. Learned counsel for the petitioner shall carry out the amendment in the cause title and furnish amended cause title within a period of 1 week from today. Yes.
I represent the fourth respondent in this serial number 32. But, they filed application for early hearing. But any date may be fixed for a hearing.
ಏನಿದೆ ಇದರಲ್ಲಿ ಅಂತ ಹಿಯರ್ ಮಾಡೋದು ಏನಿದೆ
ಅದರಲ್ಲಿ the khata entered in
you are appearing for the town municipal council.
Yes.
ಏನು what is the grievance of the petitioner?
Flood.
Asking for a mandamus
they farmed
to effect khata.
Yes.
What is the difficulty?
Earlier, the prayer for this very same prayer has been rejected by this respondent for the reason that this layout is not approved by the competent authority as required under section 17 of the Karnataka Town and Country Planning Act. That we have issued endorsement and at annexure R4E. The said endorsement is not challenged in the present petition. But on the another aspect is earlier, the officials of this fourth respondent have entered khata, which is against the circular issued by the government and which is against the section 17 of the act. We have issued show cause notice to the concerned officials. We have issued a show cause notice and we have initiated
that khata was not registered in the favor of the petitioners. You are talking of someone else.
That has been suspended because it is
no, that is in respect of some other property not belonging to the petitioners.
Very same sites.
Same sites.
They were same site which now the petitioner sought for a change of khata.
Earlier it was registered.
And thereafter it has been suspended.
Yes.
On the reason that the entire layout has not been approved by the planning authority as required under section 17 of the Karnataka Town and Country Planning Act.
All right. Yes.
It's in the page number 73.
Hmm.
The pass in order, the sole reason that the revision ಅರ್ಜಿ ಪುರಸ್ಕರಿಸಿದೆ ಅವಧಿ ಮುಗಿದಿರುವ ಅನ್ಯಕ್ರಾಂತ ಮಂಜೂರಾತಿ ಜ್ಞಾಪನ ಮೇರೆಗೆ ಪ್ರತಿವಾದಿಗಳಿಗೆ ಆಗಿರುವ ರದ್ದುಪಡಿಸಿದೆ. From the last third line. ಹಾಗೂ ದಿನಾಂಕ 7/5/2000
ಅದೆಲ್ಲ ಬಿಡಿ sir. Please tell why we should issue direction to the municipality to register the kata in your name.
Because already
The sites have been formed in an unauthorized layout.
the land has been converted.
Converted is different.
Land has been
After
converted.
conversion, the owner and the developer had to apply for the sanctioned plan for formation of the layout before the town planning authority.
Because the small extent of only.
ಅವೆಲ್ಲ ಏನು ಮಾಡಕ್ಕ Huh?
Extension was a product that we have extended the condition to apply planning authority for the plan. The condition to the extension of time of conversion. Second, this condition will be there, that they have to apply planning authority.
Yes. There is a
condition only for the 17 puntas. I have formed that 11 sites. The site has been already sold to the third parties. So earlier I have paid the admin charges also.
There is provision under the Town and Country Planning Act for grant of a single site layout. If it is a smaller extent where a big layout cannot be formed, there is provision for a single site layout. You have not approached the Town Planning Authority.
I have already left that road also. I am ready to handing over that public road.
Unless the formation of the layout is regularized in a manner known to law, we cannot direct the municipality to register kata in your name.
And even my application also is pending. If it is a suitable direction is issued to the, I will gone to that application. They did not consider my application also.
Correct. ಈಗ ಏನ್ ಮಾಡ್ಬೇಕಂದ್ರೆ we can't issue a direction.
No, we will approach the 4% as per the order. And the approach to be considered as per license.
Approach you whom? You will approach whom?
The fourth respondent.
Huh?
You have to approach planning authority for
Planning authority.
Planning
Sir. You have to approach the planning authority. But the grievance of the petitioner is that in respect of the residential site was made out in the name of the petitioner earlier with the town municipal council, Malavalli. Nevertheless, subsequently, it was cancelled by the deputy commissioner. In terms of the impugned order at Annexure L, dated 7/1/2020. Stop. Thereafter, the petitioner has once again approached the town municipal council seeking registration of the kata on the ground that the sites were formed in an extent of 17 guntas of land after the same was converted by the deputy commissioner in terms of section 95 of the Karnataka Land Revenue Act, 1964. Stop. Next para. For contra, learned counsel for the respondent town municipal council submits that all the kata was registered in the name of the petitioner in respect of the individual site. Nevertheless, the deputy commissioner has directed cancellation of the kata, taking note of the circulars issued by the state government. Full stop. It is submitted that the state government found that many such unauthorized layouts were formed and are being formed, and the local bodies have been registering khatas in respect of individual sites which were not approved by the competent authority. Therefore, all the local bodies were directed to cancel the khatas registered in respect of individual sites formed in unauthorized layouts. Stop. Next para. Having regard to the submissions made by the learned counsels, this court is of the considered opinion that the petitioner cannot seek registration of khata at the hands of the fourth respondent, Town Municipal Council, Malavalli, unless the Town Planning Authority grants approval to the layout. Stop. If it is permissible in law for the Town Planning Authority to consider a post facto grant of approval, then the planning authority may consider such application which could be filed by the owner of the land who carved out residential sites in the said 17 guntas of land. Stop. As and when approval is granted by the Town Planning Authority, only then the petitioner may approach the Town Municipal Council for registration of khata. Full stop. Ordered accordingly.
Published.
An inquiry should be initiated, not in terms of my representation, but in terms of the previous directions which have been issued by the state government itself, as against the errant directions of the state.
What is the prayer in the writ petition?
The prayer is going to be to initiate the inquiry in terms of the representation as well as the previous. It's on page 20. Our representation is to initiate the inquiry in terms of the previous directions which has already been issued by the government. Government has said initiate an inquiry, and not kindly see. For one moment, if I could just take the lordship, first direction was issued by the state at running page 162. It was the last time when I'll just finish it. Last time also we requested. Not a submission was made, not the last occasion, your lordship may kindly see the order sheet dated 5/4/23. A categorical submission is made by the council for the society saying that they have been absolved in the very same controversy. 5/4/23. 19/4 minutes they said the report is also there, and where is the report before the court? Now minutes, by whatever I am able to gather minutes on this issue, there has been no inquiry so far, despite repetitive directions by the
Yes,
state.
Mr. Devanand.
2011-2022 dates are very necessary.
No, you had made a statement that has been recorded. Which is that? Huh?
2011-2022. Mr. Prabhu, the senior inspector, was appointed as an inquiry officer. And we gave a notice to us on 19/12/2022. We did appear in the society. On thereafter, in the course of the further case, three directions were issued by him or necessary regulatory certificate in respect of each one of the charges. They are all given. Now, the inquiry has been completed. Purpose of inquiry of hearing has been completed.
A point out May I kindly take over to the first direction.
You have filed statement of objections?
There is no statement of objection for the past 2 years. There will not be, because there will not be any statement of objection. 162, that's categorically a direction.
Allah, in fact, it was directed. He seeks for a week's time to file statement of objection along with the report.
Yeah, tomorrow. I'll file this as annexure.
Purple.
Bring it to the notice of the report. Not to make out of.
I will only point.
Learned Counsel Sri R.A. Devanand, appearing for respondent number 5, submits that the statement of objections along with the documents to show that the inquiry was held as was directed by the state government will be filed within a period of 4-5 days. Full stop. Release this matter on 28th of June. Sorry, you are concurring with him. If that is correct, then what survives?
On this.
Anyway, let it, you please file it and
I will just point out what is
ಅದನ್ನ ಕೊಟ್ಬಿಡಿ ಅವ್ರ ಒಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ we will close the case.
the adjectives may be uttered with a bit of ease.
Let us see.
Adjectives may be here.
Number 34. Euroma HC.
In disposal of matter. Or on IA number 2 of 2023. This writ petition was disposed of on 22/2/2023. So, however, this application is filed by the petitioners seeking return of the original endorsement dated 12/8/2021 at annexure F. Since the same is required to be produced before the civil court, where a dispute is pending in OS number 6247 of 2017 before the principal city civil and sessions judge. ಎಲ್ರಿ annexure F ಒರಿಜಿನಲ್ ಅಲ್ಲ ಇದು. Next para. On going through the records, this court finds that annexure F dated 12/8/2021 is only a true copy and not the original. Stop. Nevertheless, if the petitioner requires the same, the same may be returned to the petitioner while retaining a copy for the file. IA is accordingly discharged. Yes. Yes.
Petitioner is 5.1 minus. Change the matter in the morning manner. So weeks accommodation.
But the petitioner in the first petition has filed this application for posting. Huh? There are only two matters. Ian, what is the matter about? The kata has been
Now we want to restore the data back. For which proceedings are initiated? As per the Act 134 of the
you were directed to file statement of objections.
One, the second one, the same.
You will adopt the same. Learned counsel for the respondent BVMP submits that statement of objections have been filed in WP number 2480 of 2022. You have received a copy? Huh? A copy of which has been served on the learned counsel for the petitioner. We'll stop. However, in the connected writ petition, the statement of objections will be adopted. Stop. Learned counsel is requested to serve a copy of the statement of objections on the learned counsel for the petitioner in the connected matter. Stop. Why have you filed this memo for posting? You have not stated what is the urgency. What is the use of simply filing a memo for posting like this? Huh? Yes.
Interim order maybe.
What interim order?
The stay has been granted on the proceedings.
Interim order granted earlier stands extended till next date of hearing. Yes.
Any date next week, my lords.
I'm ready to go.
There are so many old matters pending. Huh? Let us see. Yes.
This with regard to the orders passed by the Assistant Commissioner. It has been stayed, my lord.
On that basis, only Assistant Commissioner have passed the order.
My lord, may I make a suggestion? Now the respondent is pitching upon the title of the property. There is a dispute in the title. If at all, if there is a dispute in the title, the respondent can approach the civil court and get it decreed, if at all. My ground is that Assistant Commissioner has exercised the jurisdiction of the Deputy Commissioner under Section 306 of the Municipalities Karnataka Municipalities Act and passed the orders as per Annexure R, my lord.
You could not have passed that order.
Yes, my lord. That's what.
Who approached the executive officer?
Respondent number 1, my lord.
You have approached the executive officer. Assistant Commissioner. Assistant Commissioner. This is under the Municipalities Act.
Municipalities Act.
So you approach the Assistant Commissioner under Section 306. Let us see Section 306.
Clause 1. If the opinion of the Deputy Commissioner, the execution of an order or resolution of a town municipal council or the doing of anything which is about to be done or is being done by or on behalf of a town municipal council is unlawful or is causing or is likely.
Is there any delegation of delegation? Huh? It's probably a delegation to the Assistant Commissioner.
But that is not there.
Otherwise, you would not have entertained this.
Yes, please, my lord. The enactment does not mandate.
We do not know if the state government has delegated that authority under 306 in certain cases to the Assistant Commissioner, then he is empowered to consider this appeal.
Okay. And my humble submission is that the interim order was passed in the last occasion.
Let us consider all your contentions, but we should have the correct information also.
Adralli typographical error ಆಗ್ಬಿಟ್ಟಿದೆ.
Adralli
interim order pass ಮಾಡುವಾಗ typographical error ಆಗಿ municipal council municipal corporation act ಅಂತ ಮಾಡಿದ್ದಾರೆ. That is not municipal corporation act, that is as per Karnataka Municipalities Act.
ಆಯ್ತು. That will not
ಗಮನಕ್ಕೆ ಅಷ್ಟೇ
ಸುಮ್ಮನೆ. Since it is sought to be contended by the learned counsel for petitioner that respondent number 1 could not have approached the Assistant Commissioner, Tumkur subdivision, invoking Section 306 of the Karnataka Municipalities Act, 1964, learned AGA is requested to secure instructions as to whether the power conferred on the Deputy Commissioner under Section 306 of the Act has been delegated to the Assistant Commissioners in certain cases. Full stop. Next para. Release this matter on 28th of June. No. Respondent number 5 was here. That is why, see, this is why I don't adjourn the matters. I am very careful. I don't adjourn the matters. But if these kind of things happen, that one of the learned counsels appears on the other side and says no objection, what to do? Huh? No, I've given a date. Well, it doesn't make any difference. Yes. Let us see. Yes. Huh? At the request of learned counsel for respondent number 2. At the request of the learned counsel for the respondents, 2 weeks time is granted to file statement of objection.
of the here the petitioner was co-opted as one of the members of the society. On Mr. N.S. Ramanaya. Election was held on 3rd February 2019 and he died on 1st of March 2021. So there was still 2 years, 11 months left for
Co-option.
not co-option, an election has to be held.
Co-option first and then election.
And he says that if it's more than half of the term, then it has
Correct.
to be election.
Correct. So in the meanwhile, as a stopgap arrangement, they could still have a co-opted member. Anyway, what is the
My grievance is that they could not, they should have, they also have conducted the election, but they have co-opted the petitioner.
which is the judgment that you are saying? The
The judgment. We have produced it along with the statement of objection. It is
Statement of-
the government secretary, cooperative society limited for state of Karnataka. It appeal number 6099 of 2017.
page number
Page number 60. Statement of
R2.
yes. Here, the plain reading of section, paragraph number 3, page 70.
Yes, yes.
Plain
Yes.
reading of section 29E of.
Yes, I have seen this. I have seen this. And you have conducted the election.
Election has not been conducted.
Huh?
He has been co-opted, merely co-opted.
My lord, what happened?
And even returning
There
officer
was a
was
government
appointed.
notification.
He has been co-opted.
Uh,
Then why is he before this court?
There was a notification, my lord, not to conduct election for a period of 6 months.
Why has he come before this court?
He shouldn't have come.
It's
Yeah,
because,
what
my
is the
lord,
prayer in the writ petition?
the order that is passed at National W, my lord.
Huh?
The order that is passed at National W.
Who are you?
I'm the person who has been co-opted.
Ah,
And by an order, my lord, National W,
ah.
page 55, have been disqualified. My co-option has been cancelled without hearing me.
Where is the question of hearing you, sir?
No. And the adverse order is passed without hearing me, an order is passed.
An adverse order. They have only directed holding of election.
Well, I have not been notified.
Huh?
If your lordship kindly look at the National W, my lord, page 55.
Yes. Yes.
I have not been made a party and I'm not.
Why should you be made a party? It is a process of law.
Allah, it's like this, my lord. See, the vacancy arose on 1/3/2021.
Please see the provision, sir.
My lord,
Please see the provision.
1/3/2021, my lord.
Please read the provision first, sir.
But in the meanwhile, what has happened was,
It is only a stopgap arrangement, that's all.
in the meanwhile, what happened was, my lord, Annexure F, my lord, page 28. There was a notification by the second respondent.
Yes, sir. That has to be done in accordance with law.
Allah, appointment agito, returning as appointment agito. In the meanwhile, what happened was, the second respondent issued a notification. On 21/6/2021.
You see the second proviso.
And Annexure F, Annexure F.
29E second proviso, David Odi.
Annexure F.
I will read it for you.
Annexure F.
Please
page-
listen, sir.
Page 28.
I will read it for you. Please listen. Provided further that the board may fill up casual vacancy of the board by nomination out of the same class of members in respect of which the casual vacancy has arisen till the election is held for such vacancy.
That is true, my lord.
It's only a stopgap arrangement.
Annexure F by KDVC for movement, my lord.
Yenike.
And the government notification was there to postpone the elections for a period of 6 months from 28/4/26, 21/6
So?
up to 30.
ಅದೆಲ್ಲ ಆಯ್ತು ಇವಾಗ election has been held.
ಅದಕ್ಕೆ ಪ್ರೋಸೆಸ್ ಇದೆ, ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದಾರೆ.
How do you get the locus to challenge all this?
ಅಲ್ಲಲ್ಲ, ಏನಾಗಿದೆ?
You don't get a vested right, sir.
ಅಲ್ಲಲ್ಲ, ಏನಾಗಿದೆ?
You are only a co-opted member in terms of the provisions.
Subsequently, my lord.
You can't challenge the elections that is to be conducted in terms of the provisions of law.
ಅಲ್ಲ, ಏನಾಗಿದೆ? For movement, my lord. Annexure F by KDVC looked into. There was notification by the second respondent. to
Although
postpone the
during
elections,
COVID times, it was extended.
postpone the elections.
Yes.
for a period of 6 months.
ಹೌದು
That come to an end on 31/10/2020.
ಸರಿ
On that date, particular date, there was a less period, remaining period was only less than 2
so you think that benefit should inure to you? What is your locus, sir?
The society could not.
What is your locus?
What is?
You are only nominated and appointed. It is not an election. It is a co-option in terms of the provisions of law, only as a stopgap arrangement. You will not get a vested right.
The society could not conduct the elections between 26 to 21,
Yes, yes.
21 to 31,
Yes.
21.
No doubt.
And at that relevant point of time, my lord, the remaining part was only told of less than.
How are you to take the benefit of that one? What locus do you get?
Option is by the society, my lord.
Howdu, sir. It is done only in accordance with the provisions contained in 29E.
The data-
29E says that till the elections are held to fill up the vacancy, a member will be co-opted. What right do you have
Then,
to
my lord,
amend
the
content
society-
before this
the
court?
society could not conduct elections because there was a notification by the second respondent.
Sir, I understood, sir. You don't have to repeat that.
For that
My
reason,
question is, what right, vested right do you have to come before this court and say the elections were held subsequently when the period of the remaining term was less than 2.5 years, and therefore they should not have held the election?
Yes,
Who are you to say that?
that is what the provision provides, my lord. If it's less than 2.5 years, then the society can co-opt as per the provisions of the bylaws.
Yes.
As per the provisions of the bylaw, my lord, have been co-opted.
Sir, where do you get the vested right to come before this court? You will have to satisfy this court first, that you have a vested right to say, I should continue in this post.
Because I've been co-opted according to.
Where is the vested right?
My lord, as per
You are co-opted only in terms of the provisions of this act.
bylaw, the act says, my lord,
Correct, sir.
if the remaining. period of-
When you are co-opted and the judgment of the division bench, you please read the judgment of the division bench. Please give a copy to him. You have a copy of that judgment? Division bench. Please read.
ಅಲ್ಲ ಓದಿದ್ದೀನಿ
ಹಾ.
even then, my lord, even this provision was there, then my submission to your honor, to your lordship is that unnecessary EF can be looked into government notification where the elections to fill up the vacancies could not be held up for a period of 6 months. Because of that, my lord, the society could not conduct the elections. And after the term was also.
That has been clarified in the order of the division bench, sir. Please read.
This, see, the
Yeah.
process.
Please read it, sir. A plain reading of section 29E of the act extracted above indicates that the remaining term of office of the board referred to therein has to be computed from the date when the vacancy in the office of the director of the board occurred and not from the date of notification to fill up the vacancy.
My lord, one submission I would like. See, on the date of vacancy, is the procedure which will be followed by the returning officer to appoint and the conduct elections, prepare the voter list and default list and all these things. Process will have to.
ಈಗ ಎಲೆಕ್ಷನ್ ಆಗೋಗಿದ್ಯಾ?
ಇಲ್ಲ, ಅದು ಯಾವ್ದು ಆಗಿಲ್ಲ.
Why?
ಅದು ಆಗೋಷ್ಟೊತ್ತಿಗೆ
Huh?
this notification came into force.
Was there Why?
5 years term has not been completed.
Huh?
Even they have not, society is sailing with the petitioner. They were supposed to make certain documents available to the returning officer and that has not been done. And that is.
ಯಾಕೆ ಮಾಡೋಕ್ಕಾಗಲ್ಲ?
Connection will be produced by.
You are appearing on behalf of whom?
Respondent number 5.
Who is respondent number 5?
Respondent on his representation, this option was
Removed.
Yes, you are. By the. Respondent 5 is
There is an issue.
representation.
Removed without holding election.
Without holding it.
How?
To conduct election. The election was.
Why? Where was the need to remove him before conducting the election? Then again, a gap will not be created.
Vacancy has to be filled in with.
As and when election is conducted and the person is elected, his nomination will go.
clarify on that point.
ಏನ್ರಿ ಏನೇನ್ ಮಾಡ್ತಿರ್ರಿ? We can't understand the procedures that are being followed. Is there an interim order here?
Is it in-
Directing what?
W annexed.
Even if that is so, why elections are not conducted?
Annexed to they say that documents have not been supplied to the returning officer by the society, respondent to the society.
The election was required to be conducted by the election commission. And you have not made the election commission a party here?
Period, remaining period, my lord, is less than 2.5 years.
Adhan consider Marana, sir. Why have you not implemented the election commission?
My lord, my portion is cancelled by the authority who has no power, who has no jurisdiction.
Arkale. The presence of the election commission, state election commission, is necessary for consideration of the prayer made in the writ petition. Full stop. Therefore, the petitioner is directed to implead the state election commission commissioner as a party to these proceedings. Full stop. Learned counsel shall carry out the amendment in the cause title. Forthwith. Full stop. Next para. Learned counsel Srimati Vaishali Hegde. Vaishali Hegde is requested to take notice for the newly implemented state election commission. So, learned counsel for the petitioner is directed to serve a copy of the 2 sets of copies of the writ petition along with the lectures on learned counsel for the respondent state election commission. Full stop. Reads this matter on 28th of June.
Meanwhile, I pray for a
Interim order granted earlier stands extended till the next date of hearing. Yes.
Direction to BBMP Commissioner to execute the sale deed according to the notice issued by the respondent. It is annexer. Notice dated annexer.
To direct the BBMP.
Annexer H.
Page number.
Costing annexer H.
Page number.
Page number, that is 71 H. I have challenged the endorsement. ಅದರಲ್ಲಿ ಉಲ್ಲೇಖಿತ ಸರ್ಕಾರದ ಉದ್ದೇಶದಲ್ಲಿ ಆಸ್ಟಿನ್ ಟೌನ್ ವಾರ್ಡ್ ನಂಬರ್ 17 700 ಗ್ರಾಹಕರು ಮಾರಾಟ ಮಾಡಲು ದಿನಾಂಕ 18/5/1978
extend the time period for execution of the sale deed.
ಹಾ ಸೇಲ್ ಡೀಡ್ ಅದನ್ನೇ ಈ ಪ್ರಕಾರ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ಅವರು ಸೇಲ್ ಡೀಡ್ ಮಾಡಿ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ನನಗೆ. ನಾನು 14,404 ರೂಪಾಯಿ ಕಟ್ಟಿದೆ ಬಿಬಿಎಂಪಿ ಆ ನೋಟಿಫಿಕೇಶನ್ ಪ್ರಕಾರ.
Why is this allotment made?
The properties belongs to the BBMP. That's why his long period he has residing in that house. Hence the BBMP issued the notice according to the notifications. The executive sale deed will be executed. You pay that amount. That's why the petitioners paid the amount to the BBMP. But even though he was not executed the sale deed, I have filed the writ petition before this honorable court. After observing all the contents of the petition, he directed to BBMP to execute the sale deed according to his representation. I have produced the honorable high court order.
Who is appearing for BBMP? No, you are impleading applicant. I know.
My rights have been declared final in my favor. There was a private dispute on the right to the property. It has been decided in my favor.
By a civil court.
Yes, by a civil court. And appeal filed by his client with this person.
In respect of the same property.
Same property. They went to the, after we lost, we filed a petition for maintenance.
So it's not a property belonging to the BBMP.
No, no, no. The rival claim. I get it from the BBMP. We were entitled to allotment to the BBMP. Rival claims were made.
Uh-huh.
Finally decided for the civil court. After losing the matter, the civil court and the regular person, they filed a petition before this court, making only the corporation, like the same model of operating that happened before the law.
Yes.
They filed a petition to making as a party and not disclosing the fact that they suffered a judgment. And by suppression of the fact, they had a direction from the court not to transfer the carta, to consider it in accordance with law. Thereafter, the corporation, we wrote a letter that when we got to know of the High Court order, they were trying to get the corporation to transfer the carta and suppression of the judgment. We wrote to the High Court, to the corporation, that there is another connected matter pending. And therefore, the corporation wrote back saying that since the RFA is pending, we cannot proceed further. And you see, the document at page number 21, after the High Court order. You ought to find that page number 20, at page number 18, may I first take the court to the order. Page number 18.
You have filed a statement of objections, is it?
Yes, yes.
When?
Along with my appealing application. Or may I just pass the judgment of the High Court?
No, Religiano? Only your application for implement is
Yes,
there.
yes. I just want to two things about that.
We'll continue at 2:30. Note that seeker statement of objections.
Depending on. Court officer. Court officer. Court officer. Hello, court officer. Court officer.
16, 18 ಎರಡು
Court officer.
next week.
ಒಂದು ಈಗ ನನ್ನ ಹತ್ರ ಇದೆ. ಒಂದು ಮತ್ತು ಎರಡು ಈಗ ಒಂದು.
Sir, court officer. Sir, court officer. Mute ಇದೆ. 2:30 ಇತ್ತಲ್ಲ ತಗೊಳ್ತಾರಲ್ಲ ಸಾಹೇಬ್ರೀಗ ಅಥವಾ ಬೇರೆ ಪಾಸ್? ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
There. ಅಯ್ಯ ಅಲ್ಲಿ ಹೋಯ್ತಾ?
ಏನು ಮಾಡಿದ್ರೆ ಎಲ್ಲೋಯ್ತು?
ಇಲ್ಲಿ ಸ್ಟಾರ್ಟ್ ವಿಡಿಯೋ ಮಾಡಿದೆ. ಸ್ಟಾಪ್ ವಿಡಿಯೋ. ಬಂದ್ರು ಸರ್ ಸಾಹೇಬ್ರು. ಇದೇನಿದು?
ಅವೇ ನಮ್ದು ಬಂದಾಗ ಬರುತ್ತೆ ಮೇಡಮ್ ಅಲ್ಲಿ.
ಇಲ್ಲಿ ತೋರಿಸ್ಬೇಕಲ್ಲ ನಮ್ದು. ಇಲ್ಲಿ ಸೈನ್ ಇನ್.
ಇದು ಅದೆಲ್ಲ ಕ್ಲಿಕ್ ಮಾಡ್ತಾರಲ್ಲ ಹೆಸರು ಬರ್ತಾ ಇರ್ತವೆ, ಅವಾಗ ಬರ್ತದೆ ಎಲ್ಲ ಒಂದ್ ಕಡೆಯಿಂದ.
ಇದು ಯಾವ್ದು AI ಅಂತ ಅವಾಗ್ಲೇ ಬರ್ತಾ ಇತ್ತು. ಇದು
Leave of this honorable court, if I may make a humble request in a matter pertaining to Court Hall 9, there's extreme urgency in the matter. On 14th of June, the family court has passed an order of interim custody in favor of the father, contrary to its own order passed 6 months back.
Tomorrow you move the regular court.
Lord, the case in the
Please
family
move it
court is
before the
closed. I
regular court
apologize.
tomorrow morning, sir. Yes. Huh? Huh? This has already been ordered in that matter. It will come up, it will come up, yes.
40, period number 40. Affiliation.
I am per the respondent, BBMP, my lordship.
Huh? But they have furnished a copy of this RFA.
Yes,
You
I
have
have
furnished
produced
a copy of the
the RFA.
Ah.
It is what endorsement given by the BBMP. I have produced the RFA, my lord. But before petition in the order,
No. What has happened? RFA has been
disposal, my lord. Disposal, my lord. I am not party in that RFA.
Huh?
I am not party in that RFA. I am third party. They filed a suit, relation between them. They said that if it is executed by one more and getting the order from the court, not against the BBMP. BBMP also one of the formal party.
What do you mean formal party?
BBMP, the suit.
Property belong to the BBMP.
BBMP, yes, BBMP.
How can you say it's a formal party?
My lord, not against the BBMP, they filed a suit to execute the sale deed. Between the parties themselves, he filed a suit.
Correct, sir. But the ultimate prayer is that the person who has approached the court is entitled to have a sale deed registered at the hands of the BBMP.
Still, it is not executed the BBMP in favor of them. Without getting the sale deed from the BBMP, they filed a suit.
Is a formal party.
Yes.
See, if BBMP was of the opinion, no, this person, both these parties are not entitled. It would have made a submission. No, there's one more party who is entitled for the allotment, and we can't allot this property either of them. It could have taken a stand.
My lord, before filing the suit, they nor getting the notice from the BBMP, nor claiming the title from the BBMP. Originally, the properties belongs to the BBMP.
Correct.
I am the position. I am enjoying the property.
So,
according to notification, government order.
Therefore, BBMP could have taken a stand. Neither of these parties are entitled for allotment. There is one more party.
No. Between.
Atra ಹೇಳಿಲ್ವಲ್ಲ ಅವರು BBMP ಅವರು.
ಅವ್ರು ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ. ನಾನ್ ನಿಮಗೆ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಸೇಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ನಂದೇನು ಅಭ್ಯಂತರ ಇಲ್ಲ. ಬಟ್ RFA ಪೆಂಡಿಂಗ್ ಇರೋದ್ರಿಂದ ಏನಪ್ಪಾ ಅಂದ್ರೆ ನಾನು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂದ್ಕೊಂಡೆ ಅವ್ರ ಎಂಡರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದು ಸ್ವಾಮಿ ಅಷ್ಟೇ. ಒರಿಜಿನಲ್ ಸೂಟು ಡಿಸ್ಮಿಸ್ ಆದ್ಮೇಲೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆದ್ಮೇಲೆ ಅವ್ರು RFA ಹಾಕೊಂಡು. ಆ RFA ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ಲೋವರ್ ಕೋರ್ಟ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅನ್ನ ಸೆಟಸೈಡ್ ಮಾಡಿ ಒರಿಜಿನಲ್ ಸೂಟ್ ಅನ್ನ ರೆಸ್ಟೋರ್ ಮಾಡಿದ್ರು. RFA. ಆ RFA ನಲ್ಲಿ ನಾನು ಪಾರ್ಟಿ ಇಲ್ಲ. ಒರಿಜಿನಲ್ ಸೂಟ್ ಡಿಗ್ರಿ ಆಧಾರ ನಾನು ಪಾರ್ಟಿ ಇಲ್ಲ. ಬಟ್ ಅವ್ರು ಹೇಳೋದೇನು ಅಂತಂದ್ರೆ BBMP ದವರು ಕೂಡ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಾಗ ದಿಸ್ ಬಿಲಾಂಗ್ಸ್ ಟು BBMP ಪ್ರಾಪರ್ಟಿ ಅಂದ್ಕೊಂಡು ಹೇಳಿ ಅವ್ರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರು. ಅಲ್ಲಿ BBMP ಅಗ್ನಿಸ್ಟ್ ಏನಪ್ಪಾ ಡಿಗ್ರಿ ಮಾಡಿಲ್ಲ. ಅಲ್ಲಿ ಅವ್ರ ರಿಲೇಷನ್ ನಲ್ಲಿ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಗಿಫ್ಟೆಡ್ ಮಾಡಿದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ. ಆ ಗಿಫ್ಟೆಡ್ ಪ್ರಕಾರ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಪ್ರಾಪರ್ಟಿ ನಮಗ್ ಸೇರ್ಬೇಕಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಆ ಗಿಫ್ಟೆಡ್ ಮಾಡೋಕ್ಕಿಂತ ಮುಂಚೆ ವೆದರ್ ದೇ ಆರ್ ದ ಓನರ್ ಆರ್ ನಾಟ್, ದಟ್ ಈಸ್ ದ ಸಪ್ರೆಷನ್ ಆಫ್ ದಿ ಫ್ಯಾಕ್ಟ್.
ಅಲ್ಲ ಸರ್, whoever filed the suit went before the civil court saying we are entitled, I am entitled for execution of a sale deed.
ಇಲ್ಲ ಹಂಗ್ ಡಿಗ್ರಿ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, ಹಂಗ್ ಡಿಗ್ರಿ ಮಾಡಿಲ್ಲ. For the purpose of execute the sale deed, they are not filed the suit.
Where is that?
That is
Where is that decree? Why have you not furnished a copy of that decree?
Yes, my lord. That is original suit.
Do you have a copy of the decree?
Yes, I have produced that original suit order. Judgment and decree.
They had filed an appeal.
The petitioner before my law.
My lord.
And this is suppressed very convenient.
No, I am not. Judgment and decree. And original suit, judgment and decree.
What is the suit? Judgment and decree. It is the suit. It is the suit.
Johnson alias John.
Suit alert. This is the suit. Original suit.
In fact, my lord, the present petitioner himself filed RFA 737/23. The present petitioner,
1718.
he filed an implementing application order at 21 rule 9 and it seems, and execution petition ಅಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಗಿರ್ಬೇಕು ಅಂತ ಕಾಣುತ್ತೆ. Annexure F, my kindly look into my lordship. Annexure F. He himself is the petitioner, appellant in RFA 737/23, my lord. Annexure F.
Execution petition.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಇವರು ಆರ್ಡರ್ ಆಗಿ ಅದರ ಮೇಲೆ RF ಇವರೇ ಹಾಕದಂಗಿದೆ. RFA 737/23 Annexure F. Lawrence D'Souza, he is the appellant herein. The petitioner here.
One Lawrence D'Souza, son of Joseph, came up with an application under Order 21, Rule 58,
Yes.
and sought for adjudication the above matter. So you have opposed the execution.
Execution proceeding. I have opposed the execution filing application.
Thereafter you have filed
that application is rejected. I filed an RFA before the RFA. That was pending. That was pending.
That was pending.
That was pending.
Decide ಆಗಿದೆಯಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ 737 of 2023. Present.
1718.
1718 ಅದು ಬೇರೆ ಸ್ವಾಮಿ ಅದು. ಇದು 737 of 2023.
Philomena Lourdes Mary.
Philomena is the absolute owner. Philomena ಏನಪ್ಪ ಅಂತಂದ್ರೆ ಅವ್ರು ಹೇಳೋದೇನಪ್ಪ ಅಂದ್ರೆ ಬಿಫೋರ್ ಏನಪ್ಪ ಅಂದ್ರೆ ಅವ್ರು ಒಂದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್
ಹೇಳ್ರಿ. Petitioner number 2.
ಅದೇ ಸ್ವಾಮಿ ಫಿಲೋಮಿನಾ ಏನಪ್ಪ ಅಂತಂದ್ರೆ ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಆಕ್ಚುಲ್ ಒರಿಜಿನಲ್ ಸೂಟ್ ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ದಿ ಒರಿಜಿನಲ್ ಸೂಟ್. ದಟ್ ಪಿಕ್ಚರ್ ವಾಸ್ ಕ್ಲಿಯರ್ ಪಿಕ್ಚರ್. ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ದಿ ಒರಿಜಿನಲ್ ಸೂಟ್.
No, this Philomena Lourdes Mary also filed RFA number 1718 of 2015.
ಸ್ವಾಮಿ ನಾನು ಹೇಳೋದೇನು ಅಂತಂದ್ರೆ ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ ನಾನು ಪಾರ್ಟಿ ಇಲ್ಲ ಆಕ್ಚುಲ್ ಅಂತಂದ್ರೆ.
ರಿಪೀಟ್ ಮಾಡ್ತೀನಿ.
Subject matter is one and the same, involved the matter the same.
ತಗೊಂಡಿದ್ದಾರೆ ಅವ್ರವ್ರ ಮಧ್ಯದಲ್ಲಿ ತಗೊಂಡಿದ್ದಾರೆ ವಿನಃ ಬಿಬಿಎಂಪಿ ಅದು ಯಾಕೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು ಅಂತ ಅಂದ್ಬಿಟ್ರೆ ನಾನ್ ಸೇಲ್ ಇಟ್ ತಗೊಂಡಿದ್ದಿಲ್ಲ ಬಿಬಿಎಂಪಿಲಿಂದ, ಅದಕ್ಕಾಗಿ ನನಗೆ ಟೈಟಲ್ ಬರ್ಲಿಲ್ಲ ಅಷ್ಟೇ ಸ್ವಾಮಿ. ನಾನ್ ಇವಾಗ ಹೇಳೋದೇನಪ್ಪ ಅಂತಂದ್ರೆ ನೋಟಿಸ್ ನನಗೆ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ, ನಾನು ಓನರ್ ಇದ್ದೀನಿ, ನಾನು ಪೊಸಿಷನ್ ಇದ್ದೀನಿ, ನನಗೆ ರೈಟ್ಸ್ ಇಲ್ಲ ಅನ್ಕೊಂಡು ಹೇಳ ನಾನು ಬಿಬಿಎಂಪಿ ಅಗ್ನಿಸ್ಟ್ ಸೂಟ್ ಹಾಕೊಂಡಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಅಷ್ಟೇ ಇಲ್ಲಿ ಇರೋದು. ಅವರು ಕೂಡ ಏನಪ್ಪ ಬಿಬಿಎಂಪಿ ಏನಪ್ಪ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಸೇಲ್ ಲೀಡ್. ಈಸ್ ನಾಟ್ ಆಲ್ಸೋ ಓನರ್. ಅವ್ರ ಮಧ್ಯದಲ್ಲಿ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ಗಿಫ್ಟೆಡ್ ಆಗಿದೆ ನನಗ್ ಕೊಡಿ ಅಂತ ಹೇಳಿ ಸೂಟ್ ಹಾಕೊಂಡಿದ್ದು, ನಾಟ್ ಬಿಬಿಎಂಪಿ ಅಗೇನಿಸ್ಟ್. ಬಿಬಿಎಂಪಿ ಫಾರ್ಮರ್ ಪಾರ್ಟಿ. ಬಿಬಿಎಂಪಿಗೆ ಏನೋ ಸೇಲ್ ಲೀಡ್ ಮಾಡಿ ಕೊಡಿ ಅಂತ ಅವ್ರಿಗೆ ಕೇಳಿಲ್ಲ ಸ್ವಾಮಿ ವಯಸ್ಸಿನಲ್ಲಿ. ನಾನ್ ವಯಸ್ಸಲ್ಲಿ ಇದ್ದೆ, ನನಗೂ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ. ಆ ವಿಷಯವನ್ನ ನಾನು RFA ನಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ ಸರ್.
ಅವ್ರು ವಯಸ್ ಡಿಕ್ರೀಸ್ ಸ್ವಾಮಿ.
Now, what is the prayer in the writ petition?
ಪ್ರೇಯರ್ ನಲ್ಲಿ ಏನಪ್ಪಾ ಅಂದ್ರೆ ನನಗೆ ಸೆಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿ ಕೊಡಿ ಅಂತ ಕೇಳಿದೆ ಸ್ವಾಮಿ ಬಿಬಿ ಕಡೆ.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. Since there is a decree.
ಡಿಗ್ರಿನಲ್ಲಿ ಬಿಬಿಎಂಪಿ ಅಗ್ರಿಷನ್ ಡಿಗ್ರಿ ಪಾಸ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲೇ ಸೂಟ್ ಇದೆ ಸ್ವಾಮಿ. ಅವರು
BBMP is a party to the proceedings. The main prayer is that the BBMP has to execute sale deed in favor of the plaintiff, while the other defendant is also laying claim.
ಇಲ್ಲ, ಅವರು ಸೂಟ್ ಅಲ್ಲಿ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಬಿಬಿಎಂಪಿ ಅಗ್ರಿಷನ್ ಸೆಲ್ ಡೀಡ್ ಮಾಡಿ ಕೊಡಿ ಅಂತ ಯಾವತ್ತೂ ಕೇಳಿಲ್ಲ ಸ್ವಾಮಿ ಸೂಟ್ ಅಲ್ಲಿ. ಅದನ್ನೇ ನಾನು ಸೂಟ್ ಡಿಗ್ರಿ ಹೇಳ್ತಾ ಇದ್ದೇನೆ ಸ್ವಾಮಿ. ಅವ್ರು ಹೇಳೋದೇನು ಅಂತಂದ್ರೆ ಒನ್ ಆಫ್ ದಿ ಪರ್ಸನ್ಸ್
in spite of all your submissions and bringing it to the notice of the or notice of this court in the RFA that you are not a party to the suit and a decree has been passed which would go against the appellant. In spite of all these submissions, your contentions have been negated and your appeal has been dismissed.
unless until we getting the sale deed, we are not owner. That is the my problem. ಇಲ್ಲ ಅಲ್ಲಿ ಪ್ರಶ್ನೆ ಬಂದಿದ್ ಏನು ಅಂತ ಅಂದ್ಬಿಟ್ರೆ ನಾನು ಓನರ್ ಅಲ್ಲ ಅಂತ ಅನ್ನೋ ದೃಷ್ಟಿಯಿಂದ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು ಪೊಸಿಷನ್ ಬಗ್ಗೆ ಅವ್ರು ಕೊಡಿಲ್ಲ. ಪೊಸಿಷನ್ ಇದ್ಕೊಂಡು ಏನಪ್ಪಾ ಅಂದ್ರೆ ಅವರು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ರು ಅಂತಂದ್ರೆ ಬಿಲ್ ಅಥವಾ ಗಿಫ್ಟೆಡ್ ಮಾಡಿದ್ರು ಅಂತ ದಟ್ ಇಸ್ ವ್ಯಾಲಿಡ್ ಇರ್ತಾ ಇತ್ತು. ಬಟ್ ಅವ್ರು ಓನರೇ ಅಲ್ಲ, ಬಿಬಿಎಂಪಿ ಪ್ರಾಪರ್ಟಿ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ಅವ್ರು ಓನರೇ ಅಲ್ಲ ಅಂತಂದಾಗ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ಗಿಫ್ಟೆಡ್ ಆಗ್ಲಿ ಬಿಲ್ ಆಗ್ಲಿ ಮಾಡ್ಲಿಕ್ಕೆ ಅವ್ರಿಗೆ ಪವರ್ಸೇ ಇಲ್ಲ. ಅನ್ಲೆಸ್ ಅಂಡ್ ಗೆಟಿಂಗ್ ದ ಪ್ರಾಪರ್ಟಿ ಫ್ರಮ್ ದಿ ಬಿಬಿಎಂಪಿ ದೇ ಆರ್ ನಾಟ್.
Where is the original decree?
Original decree here, my lord. ಅದನ್ನೇ ನಾನು ಡಿಗ್ರಿ ಅವರು ನನಗೆ ಗಿಫ್ಟ್ ಇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸಕ್ಸೆಸರ್ ಏನಪ್ಪಾ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸಮ್ ನಾಟ್ ಬಿಬಿಎಂಪಿ ಅಂದ್ರೆ ಅಪೋಸಿಟ್ ಬಿಬಿಎಂಪಿ ದೇ ನಾಟ್ ಫೈಲ್ ದಿ ಎಕ್ಸಿಕ್ಯೂಟ್ ದ ಸೇಲ್ ಡೀಡ್. ಸಪೋಸ್ ಅದು ಆಗಿತ್ತಪ್ಪ ಅಂದ್ರೆ ನನ್ ಕೇಸೇ ಇಲ್ಲ. ಆರೋಪದಲ್ಲಿ ನಾನು ಹೇಳಿದ್ದೀನಿ ಸರ್.
You are appearing for BBMP.
Yes, my lord.
They also filed the objection before the lower court. They said
You had filed a written statement before the trial court.
I am not aware of it, my lords.
no, he has filed the objections before the lower court stating that
Objections.
ಇಲ್ಲ ಲೋವರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ ಅವರು ದ ಬಿಬಿಎಂಪಿ ಇಸ್ ದ ಅಬ್ಸಲ್ಯೂಟ್ ಓನರ್ ನಾಟ್ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಎನಿ ಸೇಲ್ ಡೀಡ್ ಇನ್ ಫೇವರ್ ಆಫ್ ದೆಮ್ ಅಂತ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ.
ಹೌದ್ರಿ. The ultimate claim is that the property should be given to the plaintiffs.
ಸರ್ ನಾನು ಹೇಳ್ತಿರೋದೇನು ಅಂತ ಅಂದ್ಬಿಟ್ರೆ
So the BBMP should have made it clear in its written statement. Neither of these parties are entitled for allotment of this property. There is one more person in possession and that person is entitled for allotment.
ಆತರ ಅವ್ರು ರಿಟ್ ಪಿಟಿಷನ್ ಆತರ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ. ಆತರ ಹಾಕಿಲ್ಲ. ಅವ್ರು ಹಾಕಿದೇನು ಅಂತ ಅಂದ್ಬಿಟ್ರೆ this property is the belongs to the BBMP. The plaintiff is not absolute owner. ಅಷ್ಟೇ ಅವ್ರು ಹಾಕಿದ್ರು. ಈಗ ಬಿಬಿಎಂಪಿ ಪ್ರಾಪರ್ಟಿ ಅಂದ್ಮೇಲೆ ಬಿಬಿಎಂಪಿ ಅಗೇನ್ಸ್ಟ್ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಅವ್ರು ಸೂಟ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಫಾರ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ದಿ ಸೇಲ್ ಡೀಡ್. ನಾರಿ ಫೈಲ್ ದ ರಿಟ್ ಪಿಟಿಷನ್. ಅದು ಎರಡೂ ಮಾಡಿಲ್ಲ ಅವರು ತಮ್ಮಷ್ಟಕ್ಕೆ ತಾವೇ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ನಮ್ಮ ಹಿರಿಯರು ಯಾರೋ ಒಬ್ರು ಏನಪ್ಪಾ ಅಂದ್ರೆ ಬಿಲ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ, ಗಿಫ್ಟ್ ಇಟ್ ಮಾಡಿದ್ದಾರೆ. ಒರಿಜಿನಲ್ ಟೈಟಲೇ ಇಲ್ಲ ಅಂತ ಅಂದ್ಮೇಲೆ ಗಿಫ್ಟ್ ಇಟ್ ವ್ಯಾಲಿಡ್ ಇಲ್ಲ, ಈ ಒಂದು ವಿಲ್ಲು ವ್ಯಾಲ್ಯೂ ಇಲ್ಲ. ಆಕ್ಚುಲಿ ಅವರು ಒಪ್ಕೋತಾರೆ ಬಿಬಿಎಂಪಿ ಪ್ರಾಪರ್ಟಿ ಸೇರಿದ್ದು ಅಂತ ಹೇಳಿ. ಬಿಬಿಎಂಪಿ ಅಗೇನ್ಸ್ಟ್ ಅವರು ಟೈಟಲ್ ತಗೊಂಡಿಲ್ಲ. Unless until getting from the title from the BBMP, there is no locus standi to file a suit against the BBMP.
Having suffered this order at the hands of this court, ಯಾವಾಗ ಆಗಿರೋದು?
ಅದು 2005
2018.
ಇಲ್ಲ, 3 ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ ಸ್ವಾಮಿ, ಅದು ಆಕ್ಚುಲ್ ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ 2003 ನಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್.
It is, sir. You suffered an order.
I suffered an order.
2018, January 2018. ಅದಾದ್ಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರಿ?
ಇಲ್ಲ, ರೀಸೆಂಟ್ ಆಗಿ RFA ಡಿಸ್ಪೋಸ್ ಆಗಿದ್ದು ಸ್ವಾಮಿ.
ಏನ್ ಸರ್ ಇದು? What is this? You are an
ಅಲ್ಲ, ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಆಯ್ತು 2018 ನಲ್ಲಿ ಸ್ವಾಮಿ.
ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲ, RFA 1718 of 2015.
ಸರ್, ಅದು ಬೇರೆ RFA, ಇನ್ನೊಂದು RFA ಬೇರೆ, 3 RFA ಇದೆ ಸ್ವಾಮಿ. ಈ RFA ಪೆಂಡಿಂಗ್ ಇದೆ.
You are unsuccessful.
ಈ ಇನ್ನೊಂದು RFA ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ. ನಾನು ರೀಸೆಂಟ್ ಆಗಿ ಹಾಕಿದ್ದೀನಿ.
ಎಷ್ಟು RFA ಗಳು ಹಾಕ್ತೀರಾ? On the same cause of action.
Sir, same cause of action.
There were reports cost of 50,000 in the second that we had to the order.
I mean, ನಾನು ಹೇಳ್ತಾ
Why didn't you file a separate suit?
ಸರ್, ನಾನು ಹೇಳ್ತಿರೋದು,
Making a declaration
unless
that a degree passed in that suit is not binding on me.
ಸರ್, ನಾನು BBMP ಲಿಂದ ಸೇಲ್ ಡೀಡ್ ತಗೊಳ್ಳೋವರೆಗೆ ನನಗೆ ಟೈಟಲ್ ಇಲ್ಲ. ನನಗೇನಪ್ಪ ಅಂತಂದ್ರೆ ಸೇಲ್ ಡೀಡ್ ಬರೋವರೆಗೆ ನಾನು ಓನರ್ ಇಲ್ಲ. ಭವಿಷ್ಯದಲ್ಲಿ ನಾನಿದ್ದೀನಿ, ನನಗೆ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಅವರು ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಆದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ RFA ನಲ್ಲಿ there is no locus standi to file an execution petition before the lower court unless until getting the from the sale deed from the BBMP you are not title owner. ಅವರು ಓನರ್ ಅಲ್ಲ, ನಾನು ಓನರ್ ಅಲ್ಲ. ಈಗ ಅದಕ್ಕೋಸ್ಕರ ಏನಪ್ಪ ಅಂದ್ರೆ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕೊಂಡು ನೋಟಿಸ್ ಪ್ರಕಾರ ಏನಪ್ಪ ನನಗೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿದ್ರೆ ನನಗೆ ಟೈಟಲ್ ಬರುತ್ತೆ.
ಅದೇ ನೀವು ಸೇಲ್ ಡೀಡ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಅವರೇ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ BBMP ದವರೇ, ಇವಾರದ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ರಿಟ್ ಪಿಟಿಷನ್ ಹೇಳಿದಲ್ಲ ಸರ್.
ಏನಂತ
ಅವ್ರು ಹೇಳಿದಾರೆ ಕ್ಲಿಯರ್ ಆಗಿ, ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತಕೊಂಡು ಹೇಳಿ, ಅಮೌಂಟ್ ಕಟ್ಕೊಂಡು ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತಕೊಂಡು ಹೇಳಿ. ದಟ್ ಈಸ್ ಮೈ ಪ್ರೇಯರ್. Annexure H ಅದ್ರ ಮೇಲೆ ರಿಟ್ ಪಿಟಿಷನ್ ಡಿಸ್ಪೋಸ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ. Annexure H ನಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ ಅವರು. ಪೇಜ್ ನಂಬರ್ 71. ವಿಷಯ ವಾರ್ಡ್ ನಂಬರ್ ಸಂಖ್ಯೆ 78ರ ಆಸ್ಟಿನ್ ಟೌನ್ ಪ್ರದೇಶದ ಪಾಲಿಕೆ ಹೊಸ ಗೃಹಗಳ ಮಾರಾಟ ಪತ್ರ ಪಡೆಯುವ ಕಾಲಾವಕಾಶ ವಿಸ್ತರಿಸುವ ಬಗ್ಗೆ ಉಲ್ಲೇಖದಲ್ಲಿ ಸರ್ಕಾರದ ಆದೇಶದ ಟ್ರಸ್ಟಿ ಟೌನ್ ವಾರ್ಡ್ ನಂಬರ್ 71 ಮತ್ತು 76ರ 741 ವಸತಿ ಗೃಹಗಳನ್ನು ಮಾರಾಟ ಮಾಡಲು ದಿನಾಂಕ 18/5/78ರಲ್ಲಿ ಸರ್ಕಾರದ ಆದೇಶ ಹೊರಡಿಸಲಾಗಿದ್ದು, ನಂತರ ದಿನಾಂಕ 3/2/2001ರಲ್ಲಿ ಅವಧಿಯನ್ನು 1 ವರ್ಷ ಅವಧಿಗೆ ಮುಂದುವರಿಸಲಾಗಿದೆ. ಸದರಿ ವಿಸ್ತರಣೆಯಲ್ಲಿ 34 ಮಂದಿ ಕ್ರಯಪತ್ರ ಪಡೆಯದೇ ಇರುವುದರಿಂದ ದಿನಾಂಕ 3/12/2001ರ ಆದೇಶದಲ್ಲಿ ನೀಡಲಾಗಿದ್ದ ಅವಧಿ ಮುಕ್ತಾಯಗೊಂಡು ಮುಂದುವರೆದ ಅವಧಿಗೆ 1ನೇ ವರ್ಷಕ್ಕೆ 9% ಹಾಗೂ ಮುಂದುವರೆದ ವರ್ಷಗಳಿಗೆ 15% ಬಡ್ಡಿಯನ್ನು ಮೂಲ ಕ್ರಯದ ಹಣದ ಮೇಲೆ ಈ ಆದೇಶ ಹೊರಟ 60 ದಿನಗಳಿಗೆ ಪಾವತಿ ಮಾಡಿ ಕ್ರಯಪತ್ರ ಪಡೆಯಲು ಕಾಲಾವಕಾಶ ವಿಸ್ತರಿಸಿ ಸರ್ಕಾರದ ಮಂಜೂರಾತಿ ನೀಡಲಾಗಿದೆ. ಸದರಿ ಆದೇಶದಂತೆ ದಿನಾಂಕ 9/6/2006ರ ಒಳಗೆ ನೀವು ವಾಸವಾಗಿರುವ ವಸತಿ ಗೃಹಕ್ಕೆ ನಿಗದಿಪಡಿಸಲಾಗಿರುವ ಕ್ರಯದ ಮೊಗಲ ಜೊತೆಗೆ ಬಡ್ಡಿಯನ್ನು ಸೇರಿಸಿ ಪಾವತಿ ಮಾಡಲು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. ತಪ್ಪಿದ್ದಲ್ಲಿ ಸದರಿ ದಿನಾಂಕದ ನಂತರ ನಿಮ್ಮನ್ನು ಸದರಿ ವಸತಿ ಗೃಹದಿಂದ ಹೊರ ಹಾಕುವ ಕ್ರಮ ಜರುಗಿಸಲಾಗುವುದು. ಅಮೌಂಟ್ 14,404. That was paid. I have produced the receipt. Annexure J. Annexure J.
2006.
But that Annexure J.
After that, much what has told. He's lost the suit and lost the appeal. He's hinging on a
Joe. ಅದನ್ನ ಅವ್ರು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿ ಕೊಡ್ಲಿಲ್ಲ, ನಾನು ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟೆ, ಅದು ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿಲ್ಲ. ಆಮೇಲೆ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕೊಂಡೆ. ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿ ಕೊಡೋಕೆ ಆರ್ಡರ್ ಆಯ್ತು ಸ್ವಾಮಿ. ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ದ ರಿಟ್ ಪಿಟಿಷನ್ ಆರ್ಡರ್ ಕಾಪಿ. Honorable High Court order.
They suppressed this before the writ court. This appeal order was suppressed before the writ court. They didn't make the
Annexure A. Annexure A ನಲ್ಲಿ ಅದು ಪ್ರಶ್ನೆ ಬರಂಗಿಲ್ಲ ಸ್ವಾಮಿ. ಅದು ಪ್ರಶ್ನೆ ಬರಂಗಿಲ್ಲ ನನಗೆ. ಸಪ್ರೆಷನ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್ ಪ್ರಶ್ನೆ ಬರಂಗಿಲ್ಲ ಸ್ವಾಮಿ.
The same allegation is sought to be made by the petitioner against your clients. Saying
yes
that knowing fully well that they are not in the possession of the property, by their own transactions they went before the civil court and they have obtained a decree. Now the in the RFA the appeal was dismissed only on the ground of delay and laches. It is not a consideration of the claim on the merits of the matter, because it was never a claim of the original plaintiffs as against this person. So no court had the occasion to consider his claim. Yes. Yes. You please, please read the decree correctly. It says it restrains the private defendants number 5 to 6, 4 to 6 by way of a permanent injunction, not to interfere, and a direction is issued to the BBMP authorities to transfer the kata. How could the trial court give such a direction to transfer the kata when there is no title deed? Where is your title deed from the BBMP? Yes.
There was a predecessor and title of form.
Yes. Yes.
We are successful of Joseph private claim.
Yes.
Now, there was a dispute that Joseph is entitled to the government from the BBA. The successors of Joseph are in dispute.
That's what all those disputes are between some other parties, not concerning this.
No, he is a son of Philomena.
Huh?
He's Philomena's son. He is Philomena's son.
No. Philomena is not a party to the suit.
No, she is.
ಇಲ್ಲ ಸೂಟ್ ಇಲ್ಲ ಸ್ವಾಮಿ, ಪಾರ್ಟಿ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ. ಒರಿಜಿನಲ್ ಅಲ್ಲಿ ಸೂಟ್ ಅಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅವ್ರು ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
Philomena and Valerie. Philomena was the wife of Joseph. She died and he remarried a lady called Uniyama was made a party. She was to falsely represent to be Philomena. That was brought to the notice of the court and the corporation. Court found in our favor that Uniyama and Philomena are the same person and decreed to sue. Philomena then filed an obstruction.
Is there a finding?
Yes. One minute. I have to state your honor to this. Philomena then files an obstructionist application, claiming that I am not bound by the decree, I am not a party to the decree, I have an independent right, I am not Uniyama, I am separate from the decree. That obstructionist application, the first in a series of 5, first obstructionist application, came to be rejected on merits.
Yes.
That was challenged by way of other cases.
Correct.
I'm not seeing that.
Yes.
That was challenged on merits. The cogent evidence was shown that the lady Uniyama and Philomena, she been representing herself as Philomena, and that was proved before the trial court, and that is how her obstruction application came to be rejected. And then the High Court, because of delay, once the High Court passed the order in 2018, she set up 2 of her children to file obstructions number 2, obstruction number 3 applications on the very same averments as obstruction number 1 application. All those 2 subsequent obstruction applications, 2 and 3, came to be allowed by the High Court. He gave an appeal for this order to the court. I want to kindly see page number of the petition. Page number 22.
Yes.
We have an appeal against the adverse order on the second and third obstruction application. My lord will see page number 22. I am the appellant, and the respondents 1. You see, son of Joseph. He is the second obstruction application who succeeded in the trial court. He gave an appeal.
This Philomena claims to be the wife of Joseph.
And Udaya Prakash is the son of Philomena. Kindly see page number 24. The connected RFA, J. Mary, first respondent. I not have that.
Yes.
She is the daughter of Joseph and Philomena. So both son and daughter filed obstructions 2 and 3, and a common order is passed in their favor. So when mother failed, son and daughter succeeded. So we have to again come back to this court by this appeal.
Yes.
And this court, by a stinging remark, identifying the conduct of filing one after the other, and in a come to page number 54. 39. Page 54, paragraph 39.
Yes.
Perhaps to cover up dismissal of IA number 1, 23rd July 2016. My lord, this is the first obstruction application which was decided in my favor in the 18th judgment of the High Court.
Filed by this Philomena.
IA number 7 was filed by a mother's son of Srimati Philomena. With the relevant to reiterate, all 3 objective applications are filed on verbatim pleadings and assertions. Interestingly, IA number 1 was rejected earlier by an order dated 23rd July 2016, same case, without mistake. And in para 40, consequently, a decree sought to be executed for the year 2006 has ended up being dragged upon for more than 16 years. In the learned judge quotes the Supreme Court judgment.
Yes.
And then, in view of the fact, and in para 41, in view of the above factual and legal condition, point for consideration is answered. Consequently, following order. Appeals are allowed. Impugn judgment and decree on the second and third obstruction application set aside. Cost dismissed with cost of 25,000 on the son and daughter each. Udaya Prakash and Mary. Then there's a positive direction from the court. Execution court shall proceed to conclude execution proceedings by following direction given by the Honorable Supreme Court reported at 2021 6 SCC in 3 weeks. And then we go back. The third son, that is the first petition to reform a law, will come with a fourth obstruction charge. This is atrocity to legal proceedings. He comes with a fourth obstruction application, the same plea, not deterred by a warning by the court and imposition of costs on the sister and brother of 25,000 each. Unfaced, he will file another obstruction application, and the executing court saw through the fraud this time, and in the light of the judgment of this court, with the relying on the 20 of 21 judgment of the Supreme Court, eliminate dismissed it, and we see page number. Page number 64. The third judge, the executing court, page 64. The executing court refers to the Supreme Court judgment of 2021, bold law we have. And then looking at it, the application indicates that one Lawrence D'Souza has filed this application. It appears that similar application filed by Udaya Prakash, another than the brother of the judge. Apart from that, the Honorable High Court, the para 39 of this order, made it very clear to cover up the dismissal. IA number, all three objectors are filed on verbatim pleadings and assertions. Consequently, the decree sought to be executed from the year 2006 is ended being dragged on for more than 16 years. On conclusion of the case, there was a litigating case that the objector against the son of one Lord Mary claims to be in possession of suit property. The Lord Mary is JDR number 3 here. And the rightly argued that the Nation Council of the decree holder, the objectors are making all sorts of efforts to see that the decree holder will not be the proofs of the decree, but filing the same application to one after another. A similar application filed by the other family members of the application was already considered exclusively by the Honorable High Court. Direction is execution to execute the decree in 3 weeks. In these circumstances, I hold that absolutely no grounds are made out by the objector, the objection and conduct inquiry for stalling the execution. Then again, dismiss the costs, issue delivery order to police and breaking open the law. Now, this order, the law, was passed recently in 6 April 2023. This he challenges by way of RFA. Kindly see page number, the next page, Annexure F. He files an RFA suppressing again the previous and all that. And this court, a day before the vacation, day before the court's closed for summer vacation, he mentions it in the morning and gets a decision in the afternoon. And the court granted an interim stay. We appear and clarify to the court that this is a modus operandi, the stay is not extended. Then they come up with this petition, not making us a party, suppressing all of this and trying to solve that.
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಲಿಲ್ಲ ನೀವು ಇಷ್ಟೆಲ್ಲ ಆದ್ಮೇಲೆ
ನಾನು ಹೇಳ್ತಿರೋದೇನು ಅಂತಂದ್ರೆ ನನ್ನ ಗ್ರೀವೆನ್ಸ್ ಇರೋದು BBMP ಅಗೇನಿಸ್ಟ್, ಇವ್ರ ಅಗೇನಿಸ್ಟ್ ಅಲ್ಲ. ಮೇಲಾಗಿ ಅವರು ಕೂಡ ನನಗೆ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲ. ಅವ್ರು ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿದ್ರ ಅಂತಂದ್ರೆ ನನ್ನ ಅಗೇನಿಸ್ಟ್ ಡಿಗ್ರಿ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ನನ್ನ ಅಭ್ಯಂತರ ಇಲ್ಲ. ಬಟ್ ಅವರು ಕೋರ್ಟ್ ಅಲ್ಲಿ RFA ನಲ್ಲಿ ಏನ್ ಹೇಳ್ತಂದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಇಷ್ಟೊಂದು ನಾನು ಪರಿಶ್ರಮ ಮಾಡಕ್ ಆಗಲ್ಲ ನಮಗೆ. ಮೇಲಾಗಿ ಏನಪ್ಪಾ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಟೈಟಲ್ ಇಲ್ಲ, ಹಂಗಾಗಿ ನಾನು ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಎಂಟರ್ಟೈನ್ಮೆಂಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಒಂದೇ ಒಂದು ಗ್ರೀವಿಯಸ್ ಲಿಂಕ್ ಏನಪ್ಪಾ ಅಂದ್ರೆ RFA ಡಿಸ್ಪೋಸ್ ಆಗಿತ್ತು.
Court should not give any legal advice to you or your clients.
ಸರ್ ನನಗೆ
You should have advised your
ಸರ್
clients
ಒಪ್ಪಂಡೆ
properly.
ಅಲ್ಲಿ ಪ್ರಶ್ನೆ
You
ಬಂದಿತ್ತು.
file a suit saying that decree is not binding on me. ಅದನ್ನ ಬಿಟ್ಟು ಎಷ್ಟು ಸರಿ ನೀವು ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಅಬ್ಜೆಕ್ಟರ್ application.
ಈಗ ನಾನು ಆ ಸೂಟ್ ಹಾಕಿದ್ರು ಕೂಡ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ವಿ ಆರ್ ನಾಟ್ ಸರ್ವೈ ಬಿಕಾಸ್ ವಿತೌಟ್ ಗೆಟಿಂಗ್ ದ ಸೇಲ್ ಫ್ರಮ್ BBMP ದಟ್ ಸೂಟ್ ಆಲ್ಸೋ ನಾಟ್ ಸರ್ವೈ. ಈಗ ಅವರಿಂದ ಸೇಲ್ ತಗೊಳ್ಳಾರ್ದ ಕೂಡ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ನಾನು ಇನ್ನೂ ಸೂಟ್ ಹಾಕಿದ್ರು ಕೂಡ ಸರ್ವೆ ಆಗಂಗಿಲ್ಲ. Unless until you getting the title from the BBMP, that is also not survival. That's why I have filed this writ petition to getting the sale deed from the to execute the sale deed in favor of me according to notification. ಈಗ ಅವ್ರಿಗೆ ಏನಪ್ಪಾ ಅಂದ್ರೆ BBMP sale deed ಯಾವಾಗ ಮಾಡಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ BBMP ಯಾವಾಗ ಓನರ್ ಅಂತ ಅಂದ್ಮೇಲೆ BBMP ಅಗಲಿಸ್ಟ್ ಅವರು ಡಿಗ್ರಿ ತಗೊಂಡಿಲ್ಲ, ನನಗೂ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ. ಇಷ್ಟ ಸ್ವಾಮಿ ನನ್ನ ಗ್ರೀವೆನ್ಸ್ ಇದೆ. ಮೇಲಾಗಿ BBMP ಇದ್ರು ಕೂಡ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಯಾವ್ದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ. ಅದರಲ್ಲಿ ಎಂಡಾಸ್ಮೆಂಟ್ ಮಾತ್ರ ಏನಪ್ಪ RFA ಪೆಂಡಿಂಗ್ ಇರಲಿ ಅಂತ ಏನಪ್ಪಾ ಅಂದ್ರೆ ನಾನು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತಕೊಂಡಿದ್ದೀನಿ ಅಷ್ಟು ಮಾತ್ರ ಹೇಳ್ತಾರೆ. ಅವ್ರು ಅಸಹಾಯಕತೆ ಹೇಳ್ತಾರೆ. ಬಟ್ ಅವರು OS ಅಲ್ಲಿ ಏನಪ್ಪಾ ಅಂತಾರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಸಪೋಸ್ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ BBMP ಪ್ರಾಪರ್ಟಿ ಸೇರಿದ್ದು ನೀವು ಓನರ್ ಅಲ್ಲ ಅಂತಕೊಂಡು ಹೇಳಿದ್ರು ಕೂಡ ಏನಪ್ಪ ಡಿಗ್ರಿ ಆಗಿದೆ ಅಂತ ಅಂದಾಗ ಅದು ನನಗೂ ಕೂಡ ಗ್ರೀವೆನ್ಸ್ ಆಗ್ತದೆ. ಈಗ ಅವು ಸೂಟ್ ಆದ್ಮೇಲೆ ಕೂಡ ನೋಟಿಸ್ ಕೊಡೋ ಅವಶ್ಯಕತೆ ನನಗೂ ಬರ್ಲಿಲ್ಲ. ಬಟ್ ಸೂಟ್ ಆದ್ಮೇಲೆ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಅವ್ರು ನನಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದ್ರ ಮೀನ್ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ
sister has filed a suit. My law indicated that it will file a suit that affect the decree. His sister has filed a suit. Whereas 26345 of 30.
What?
His sister.
For what?
For not binding. For the decree not binding.
Yes, filed.
He has filed. Now,
Then
on one hand, one sister will go there and file a suit. Brother and sister will file obstruction.
Till now she has not filed obstruction application. She has also filed.
She has also filed and then she goes there and files this. So this is like forum shopping and my lord is aware of what's going on.
The petitioners who claim to be in long and continuous possession of an official quarters belonging to the respondent BBMP, bearing number 11, Old Cement Lane, Austin Town, Bengaluru, measuring 12 into 30 feet. Have come before this court, aggrieved of an endorsement dated 7/1/2021 and are seeking a direction to the respondent BBMP to execute a sale deed in their favor in respect of the property in question. Stop. Next. During the course of these proceedings, one Srimati Lata filed an impleading application and consequent to the application being allowed, Srimati Lata is arrayed as respondent number 3 to these proceedings. Stop. Learned counsel Sri KBS Manian, appearing for the third respondent, seeks to bring to the notice of this court various decrees and orders passed by the City Civil Court, Bengaluru, and this court. Stop. It is submitted that in OS number 15588 of 2002, which was filed by the third respondent, seeking a declaration that the plaintiff was succeeded to the suitable property and for mandatory injunction and permanent injunction against nine defendants, including the commissioner of the BBMP, and the revenue officer, concerned revenue officer of the BBMP. So, Learned Counsel submits that one of the defendants, namely, who is that defendant? Defendant number 4, Srimati Muniamma, had been making false claims that she is the wife of Mr. Joseph Raj and had been contending that she is in occupation of the suitable property and that the property has devolved on her through her husband, Sri Joseph Raj. Stop. On the other hand, it was the contention of the plaintiff that the suitable property was in long and continuous occupation of Sri Joseph Raj, Joseph Raj, and Sri Joseph Raj had who? No, the plaintiff. What was the claim of the plaintiff? How?
By way of succession.
That is through Joseph Raj only. How? Joseph Raj's father.
Lata is the granddaughter. He was entitled to that. That was born to the client. That is how the succession came.
Yenalla?
On the other hand, it is the condition of the plaintiff that social property was in long and continuous possession of
the father of Sri Joseph Raj and the plaintiff, as the granddaughter, had succeeded to the suit schedule property. Stop. Learned Counsel submits that the BBMP, which was a defendant to the proceedings, did not object to the contentions raised by the plaintiff. Stop. The plaintiff had in fact submitted that the property originally belonged to BBMP. Stop. On consideration of the evidence brought on record and having regard to the written statement filed by the respondent BBMP, the trial court decreed the suit on 19th May 2005. Declaring that the plaintiff succeeded to the rights of Susai Mary in respect of the suitable property, and the plaintiff was entitled for possession of the suitable property. Stop. The private defendants, that is defendants number 4 to 6, were directed to deliver back the possession of the suitable property to the plaintiff and they were restrained by an order of permanent injunction from either alienating the suit property or from interfering with the peaceful possession of the suit property. Stop. At the same time, defendants number 7 and 8, that is, the commissioner and the revenue officer of the BBMP, were directed to consider the claim of the plaintiff for transfer of khata in her favor. Stop. Next paragraph. Learned counsel for respondent number 3 further submits that during the course of the execution case, initially the second petitioner herein, namely Srimati Philomena, filed an application as an objector and sought a declaration that she is the owner of the property, she is in continuous possession of the property, and the plaintiffs nor the other defendants, private defendants, had any right, title, or interest in respect of the suit schedule property. Stop. The said application was rejected by order dated 16 August 2013. Full stop. In the meanwhile, a miscellaneous petition was also filed by the second petitioner herein, and the said miscellaneous petition was also dismissed. Full stop. Thereafter, the second petitioner, along with one more son, namely Johnson, filed RFA number 1718 of 2015 before this court. Stop. This court dismissed the RFA on 4th of January 2018. Stop. Learned counsel submits that two other sons of the second petitioner herein also filed similar applications for two more children of the second petitioner filed similar applications as objectors. Stop. The two applications were allowed by an order dated February 2018. Stop. However, the third respondent filed two regular first appeals in RFA numbers 217 and 218 of 2019. Stop. In a recent order dated 17th of February 2023, a recent judgment, this court while noticing the earlier application in IN number 1 filed at the hands of second petitioner herein being dismissed on 23/7/2016, and to cover up the said adverse order, two of our children subsequently filed similar applications and had succeeded in getting an order at the hands of the executing court. Stop. Stringent remarks were passed by this court while allowing the appeal and imposing costs of rupees 25,000 each on the two applicants. Stop. The orders passed by the executing court in favor of the two children of the second petitioner were set aside. Stop. Learned Counsel submits that stringent remarks at the hands of this court did not preclude one more son of the second petitioner, who is none other than the first petitioner herein, in filing similar such application as objector. Stop. The said application was filed on 1/4/2023, and the executing court, while noticing the strictures passed by this court, proceeded to dismiss the application by order dated 6/4/2023. Stop. 1st April 2023. Stop. The Learned Counsel would further submit that the daughter of the second petitioner, namely Gracie, Srimati Gracie, has filed OS number
6345 of
2013, seeking a declaration that the original decree passed in OS number 15588 of 2002 is not binding on her. Stop. Learned Counsel submits that although the petitioners have filed few of the orders and judgments that went against the petitioners, nevertheless, they did not implead the third respondent, in spite of having full knowledge that the third respondent has been contesting the matter all along. Stop. Learned Counsel submits that these disputed questions of facts cannot be considered in a writ proceedings. Stop. Moreover, the petitioners deserve appropriate orders or directions having regard to the fact that they have approached this court with unclean hands. Stop. At any rate, it is submitted that the petitioners could not have sought for a direction at the hands of this court to the respondent's BBMP to execute a sale deed in spite of having the complete knowledge of the third respondent having obtained decree at the hands of the competent civil court. Stop. Next paragraph. For contra, Learned Counsel for the petitioners submits that admittedly, the petitioners, and more particularly the second petitioner, was not a party to the original suit in OS number 15588 of 2002. Stop. It is submitted that the suit schedule property belonged to the respondent BBMP, and that fact cannot be denied even by the third respondent. Full stop. When that was the position, comma, it was impermissible for the plaintiff in the original suit to make a claim that the property devolved on her through her grandfather, comma, since a sale deed was never executed by BBMP in favor of the third respondent's grandfather. Full stop. Learned counsel submits that in spite of all these proceedings, the petitioners still continue to be in possession of the property in question. Full stop. Learned counsel has drawn the attention of this court to a notice dated 24/4/2006 at Annexure H, issued by the second respondent, Assistant Revenue Officer, comma, BBMP, calling upon the petitioner ನಾಥನ್ ಅಂತಿದ್ಯಲ್ರಿ ಅದರಲ್ಲಿ ನಾಥನ್ ಅಂತ ಬರೆದಿದ್ದಾರೆ, ಬ್ರಾಕೆಟ್ ಅಲ್ಲಿ ಫಿಲೋಮಿನಾ ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ಅದೇ ಫಿಲೋಮಿನಾ ಪೆಟಿಷನರ್ ಹೆಸರು, ಸೆಕೆಂಡ್ ಪೆಟಿಷನರ್.
ನಾಥನ್ ಯಾರು
ನಾಥನ್
ನೋಡಿ,
ಎಕ್ಸೆಪ್ಷನ್ ಅಲ್ಲಿ ಇಲ್ಲಿ ಕೆಳಗಡೆ
Nathan. His name was Nathan.
He died. So therefore, now the claimants are.
And counsel has drawn the attention of this court in notice dated 24/4/16 at Annexure is issued by the Alto Revenue Officer BBMP calling upon
the second petitioner to pay the balance sale consideration of rupees 14,404 in terms of the government order by which the period for payment of the balance sale consideration was extended. Stop. It is stated that upon payment of the balance sale consideration within a period of 60 days, along with the interest levied therein, comma, the second petitioner would be entitled to have a sale deed executed in her favor. The learned counsel would therefore submit that when the respondent BBMP issued the notice on 24/4/2006, comma, it could not have remained silent before the trial court in the suit filed at the hands of the third respondent hearing. Stop. At any rate, comma, it is submitted that the petitioners continue to be in possession of the suit schedule, property in question, and therefore a direction should be issued to the respondent BBMP to execute a sale deed in favor of the second petitioner here. Stop. Stop. Having heard the learned counsels and on perusing the petition papers, comma, this court finds that there have been several rounds of litigation between the parties. Stop. The BBMP did not take a stand before the trial court that the plaintiff nor her father, nor her grandfather were entitled for the property in question. Stop. On the other hand, it is clear even from the notice dated 24/4/2006 at Annexure H produced by the petitioners that the notice was intended to be sent to Sri Nathan, who is said to be the grandfather of the third respondent herein. Stop. The second petitioner herein claims to be the wife of Sri Joseph Raj, who is also the father of the uncle, who is also the uncle of the third respondent herein. Stop. At any rate, the dispute between the parties herein regarding the entitlement of the property in question was required to be decided by a competent civil court. Stop. The petitioners herein have failed to get the decree secured by the third respondent set aside in a manner known to law. Stop. Stringent orders have been passed at the hands of this court while dismissing the applications of the children of the second petitioner who had raised objections before the executing court. Stop. It is also a fact that one of the daughters of the second petitioner has also filed a suit way back in the year 2013 seeking a declaration that the decree passed in OS number 15588 of 2002 dated (19/5/2005) is not binding on the plaintiff. So, no adverse orders have been passed by any court of law against the third respondent or the BBMP. Stop. That being the position, this court will not be in a position to direct the respondents BBMP to execute a sale deed in favor of the petitioners. Stop. The petitioners will have to approach a competent civil court and get the decree drawn in favor of the third respondent set aside in a manner known to law. Stop. On the basis of the decree obtained by the third respondent, if the third respondent has been directed by the civil court to transfer the kata, then the executing court will proceed accordingly. Stop. The respondent BBMP shall not last sentence. Next para. For the reasons stated above, this court is of the considered opinion that the prayer made in the writ petitions cannot be granted. Full stop. Consequently, the writ petition stands dismissed.
serving and to the matter. Sipo.
I'm appearing for the petitioner, madam.
Sir,
Yes.
First ground only urge, several other grounds are also there. If the court permits me, I will also urge. If the court permits me, I will also urge other grounds, legal grounds.
ಏನು ನೀವು ಇವತ್ತು ಬಂದಿಲ್ವಾ?
ನಾ ಕೋರ್ಟಿಗೆ ಬರ್ತಾರೆ, ನನ್ನ ಜಾಯಿಂಟ್ ಪೇನ್ ಇದೆ, ಐ ಆಮ್ ನಾಟ್ ಕಮಿಂಗ್ ಟು 3 years. ಕೋರ್ಟಿಗೆ ಬರ್ತಾರೆ, ನಾನು ಇಲ್ಲೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ. ಕೋರ್ಟ್ಸ್ ಆರ್ ಪರ್ಮಿಟಿಂಗ್ ಮೀ ಬಿಕಾಸ್ ಆಲ್ ದ ಕೋರ್ಟ್ಸ್ ಆರ್ ಪರ್ಮಿಟಿಂಗ್ ಮೀ. ಐ ರಿಕ್ವೆಸ್ಟ್, ಇಟ್ಸ್ ಮೈ ಮಿಸ್ಟೇಕ್ ಆಫ್ ಮೈಂಡ್ ಬಿಕಾಸ್ ಐ ಕಾಂಟ್ ಕಮ್. I can't stand for more than 3 minutes as per the doctor advice.
Yes, sir.
Completed the argument.
ನನಗೆ ಜ್ಞಾಪಕನೇ ಇಲ್ಲ ಇದು.
May I submit, my lord? May I submit?
Yes.
My lord, the petitioner obtained loan from the respondent number bank. And an award was passed as per Annexure A.
That
additional amount for the hang malak.
Correct. The second account.
Yes.
Where there was no award passed. That has been executed. Yes. Yes. You are arguing on behalf of
Arguing on behalf of the bank.
on behalf of the bank. Yes. 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 Yes.
Before that, we can use the key that when you not use a partner and you buy 1.5, you replace also your partner of the. It was registered during 1997. Then we got there in the restriction is not for starting the order of the success fund. There is restriction number 36 of 2019. As per election fee, hereby confirming the orders passed by the sixth correspondent of 2009, and also an appreciated and also an order of the previous system order passed by the fourth correspondent. These are all the constitution review. But no may prejudice taken events. If the teacher will violate the rules of construction for trading, it's called to the tune of not 21 lakh for 1990. The first time. Then we got another 25 lakh loan was obtained. Putting a bank. Company backed by the firm.
Yes.
That loan was sanctioned upon public input property security by depositing the activities. It is payable on 16 monthly installment with 16%. Annual interest of 2% on this. It is repayable on or before 31/7/2001. Subsequently, another loan of 7 lakh was applied. Same came to the sanction during 2000. This loan is payable in 60 equal installments at the rate of 1%. That was the order. A right property of subject matter. The guidance is 4th line. Property bearing under ABC was furnished as security located with the extent of 4 acres, 15 foot bearing a rice mill, constructed in plot number 19B and C, and vacant site is known as 19A, which are 2 communities excluding the resident. Residencies are not one. Then there are simply a default copy permitted.
So there are 2 pieces of property.
3 pieces.
Huh?
3 pieces, more bhaga.
A, B and C. A is total extent of land is 4 acres 15 foot.
Yes.
Then we got the another bit of property is plot number 19B, which is the constructed area. And C is the vacant. All this covered in 4 acres 15 foot of.
Yes.
Then there are 6 default having certificate.
Hmm.
The dispute was rated in dispute number 517 of 2002. Award was passed on 10/4/2003. Award amount 11,98,050 plus 2,40,745 with 16% interest, permitting the bank to auction the property for recovery of the amount.
Yes.
Up to award, there is no dispute.
Yes.
Then there are proclamation indicated in following one. Proclamation indicated 3,23,750 plus 60,83,380.
Correct.
Now the problem started according to the procedure. Adding 16,83,389 is without procedure, declare an award.
Correct.
Therefore, it's not to ought not to have been added with proclamation.
Yes.
Then there are the tendency is dated. 7/5/2005 auction proclamation was published in the newspaper. There is no dispute. 21/5/2004 auction have conducted satisfied respondent for the highest bidder who offered ₹38. 14/6/2004 petitioner approached the board correspondent because he has dominated and requested not to confirm the same. On such reasons stated therein annexed that if the pending is of course having little significance in arguing the matter by you. Then there are 31/8/2004 fourth respondent have
ಇಲ್ಲಿ ಇದು ಈ ಪ್ರೊಕ್ಲಮೇಶನ್ ಆ ಬೋಲ್ಡ್ ಅಲ್ಲಿ ಬರೆದಿದ್ರಲ್ಲ 6/4/2004 ಪ್ರೊಕ್ಲಮೇಶನ್ ಆಸ್ ಪರ್ ರೂಲ್ ಸೋ ಇಟ್ ವಾಸ್ ಸರ್ವ್ಡ್ ಆನ್ 6/4/2004 ಆಗ್ಬೇಕಾದು
38/1 38/5
2004 ಆಗ್ಬೇಕು. Yes. Yes. Yes.
Now next we go to page 3. The
Yes.
respondent now confirmed the same as per Annex 30 on 31/8/2004. Petitioner filed a petition before dishonorable court. He has given liberty to file an appeal. 63/2009. He filed an appeal before the Tribunal appeal number 2/2004. It was dismissed as per Annex 30. Then he approached the government in Article 36 of 2009 and 10. That was dismissed as per Annex 30 on 9/2/2007. Now, these are the facts and the dispute. It's only on the factual aspect there is no dispute.
Yes.
The substance of the argument is, would there be an execution proceedings in respect of a liability? It is not a subject matter of an award.
Yes.
That precisely their point. Then the tendency don't switch out lighted by condensed. So there was an award of 14,41,691. Future interest of 16% as on 24/2003. While including proclamation in newspaper in column 8 and 9, 18,23,773 was added. There was no attachment or sale of property. Therefore, indication of auction price for 33,90,433 is there. Certain procedure including circulars of the government based on the judgment of the Supreme Court was not followed. Circular instruction they refer to is 1978 annexed. Then though the property was valued at ₹90 lakh, as per the report was submitted by the petition number 4 along with statement of objection. Only the portion of the property ought to have been sold for satisfaction of the decree or award, but not the entire property. It is the violation of principles enunciated in the following judgment, that is 1992. No certificate was obtained by the competent engineer regarding value of the property. As per the second respondent, bank submitted the valuation report before the sixth respondent at the time of argument at 59,07,900. Therefore, the option purchaser fifth respondent was uncle of the seventh respondent. Alluding me to option was confirmed to satisfy their personal experience. Why it is raised by the petitioner, there is some stereotype related to husband and wife. They are the partners of a firm. However, the bank is doing that. We are not in condition.
You are not.
Then ultimately they wanted to advert, saying that auction purchaser is no other than distinct relative of the wife. Wife wanted to help for those relatives. Therefore, he given some letter to the bank to all these things. That was the reason they wanted to argue.
Allegation.
Allegation. That is the reason, that is one of the.
Yes.
Generally, confirming the option of rupees 38 lakh, mandatory procedure and an order to 24 was not followed. There are sufficient of statement of objections I accept. The petition amendment we have denied. Second, petition admitted that it borrowed the money of 51 lakhs and subsistence. Thereafter, again it facility of 25 lakhs. Further loan was borrowed to the tune of 7 lakhs during 2002. Loan was paid in a certificate and new property, plot number so this is not in. There was an award of sum of 7 lakhs 78,000 plus 2 lakhs and lakhs, totally 40 lakhs 41,731, which is also not in. Annexed the representation for not confirmed the same is not in terms of provision under the Act and it is too far and ended. Thereafter, the option was confirmed and sale certificate was issued. There are specific exceptions which we have written in our counter to argue on the point that we are assuming for a moment I am not in the position to say to a lot of the later part of the liability is the subject matter of an award. I cannot say any part of the award, I cannot be able to say, I could not be able to say, I never say it. Still, what my submission is support? A award is wrongly executed. As your lawsuit is aware, cooperative societies act with a self-contained body is if anything is provided in detail and exhaustively. Machineries are being provided for adjudicating all the grievances from the borrowing till the execution is completed. Separate machineries are being provided. My submission is that contracts are being gradually completed. Suppose melody is illegal or irregularly an award is executed. If the machinery is provided under law, if that machinery is not available by the petitioner and can be addressed such a grievance, petition before your lordship and article is my perspective I wanted to argue. That is the reason, that's why I said, annexure B, there it is a sought for sale should not be confirmed is a grievance. While addressing that grievance, why sale should not be confirmed or not been addressed in the right of the contemplation provided under the rules and the cooperative society. If it is not addressed there, could it be addressed anywhere else where it cannot be addressed by such authority by the first argument? Let me go to next. Here, this representation for not to confirm the sale is not in terms that is yet. Here, in AR 31 GP 32, sale was confirmed. Then there was appeal was filed. Before the DRCS appeal came to be confirmed, then he filed a revision before the government. Government to also confirm. Action purchase and also for the statement. Ultimately, the fact remains entire liability was recovered. Sales certificate was issued. Action was confirmed. Third party interest has been created, and third action purchase is also party dishonorable. Next day, can we go to page 5 minutes and the questions I have formulated. Admitted facts that I narrated clearly and may not be necessary to take to losses I already read. In view of the aforesaid admitted facts, following points should be considered by dishonorable court. After passing them an award under section 70 of the cooperative society, process of execution is provided under section 100 of cooperative society. On the level of section 101 subsection 2 stop A, a machinery is provided for setting the sale. Sale held in execution or a crime or objection to an attachment of property under the Act. Under clause B1, an adjudication is contemplated about the property which is not amenable for attack or otherwise. Under clause 3, 2, 3, and 4, a relevant provision. Then at clause E, in view of the clear provision in the clause 4, any objection is preferred if it is adjudicated. A given person is provided an ability to approach the civil court within 1 year. Admittedly, this machinery is not avoided by the petitioner, as such, you cannot challenge the option put on any group as challenged in the resolution. Once a chart was created on equal property by deposit of title deed, question of attachment of such property does not arise. When once there was an award, property mortgage always amenable for the sale. Then under subgroup under 38 subgroup 2, D clause B, a procedure has been provided. Rule 38(3) as well as 4 provided machinery are required for setting aside the sale. Subgroup 5 is also important. What group sale will be set aside is provided therein. On this merit, by submitted clause is categorized according to the respondent number 1. It is a matter record. Admittedly, no release was made for subsequent machinery provided that Rule 58 India of CPC. Second, it is solid mirror, it is cooperative societies. Cooperative societies have.
Yes.
Solid. Secondly, as per Appellate, nothing is needed or a grounds are made out not to confirm the sale or any such reason. Since the petitioner have not availed statutory remedies as stated above, these issues cannot be gone into appeal filed under the provisions of the Act. However, on the result of the order passed by the Appellate Parliament, every question raised in appeal and argued before whom were considered and findings were recorded. Those findings were confirmed further by the government in division petition. Therefore, discretion available to the Honorable Court under Article 58 could not be extended to the petitioner. Even on the question of bankers' leave, the act of the land to justify. Bankers' leave is a special feature available to the banker on the ground also. Petition will be not sustainable. Then when I wanted to cite the judgment, I will take your logic. Now the question I formulated. That will articulate like this. Kindly go to the documents for a filed by them. Take it from me, the later one on a second award is not the subject matter of the award. Take it from us, there is no dispute. That we concede.
Therefore, if you concede,
Yes.
the very next question that would arise is
Yes.
whether a question of law can be raised at any stage or not.
Yes, I will come to that point.
So, then the auction and everything has to be set aside.
Yeah, that's what I said. Suppose we don't a award or in the execution process. It is illegally initiated or it is ultra virus or beyond the scope of the execution. The execution start to be executed. It is executed. Suppose if it is executed, the statute itself provides a machinery for it. Those machineries we have to avoid like keeping out. Keeping all those machineries set apart. And without avoiding those remedies as provided in law. Now he cannot make a complaint that you see it could have been done in this way, that way, this way. They are not done. Therefore, it can be it is a invalid. Such a contention you are not to have created for the. Why would they so that it is not far on their part to raise the legal issue? By sufficiently, if it is available to raise the issue, there is such a clause which can be to adjudicate Because of failure on their part to rise all the grievances and adjudications are lapsed there, it does not empower the petitioner to rise and issue before disorder court. First time. I am not only talking about the award or other things. I am going to be finding that an execution according to the complaint of the petitioner is not to be executed illegally or irregularly. If irregularity to be due in a petition under Article 223 or machinery provided under the cooperative society that could be avoided to him or not. If I could be able to show minority is not avoided by them, then court can exercise discretion under Article 226 is my question for letter. On that point, I want to move on. Therefore, I would like to take your lawsuit to be document for you. The annexure A is an award at CH-11, that is 11/4/2000. It was 40 lakhs and that there is. Then there are the important document is annexure B in a kindly. This is the proclamation under Rule 38(2)(d). 15. They kindly go to page 16. ಎಷ್ಟು ಹಣದ ವಸ್ತುವಿನ ಬಗ್ಗೆ ಮಾರಾಟವು ಆಗಬೇಕಾದ್ದು 5 ಇಲ್ಲಿ 14 ಲಕ್ಷಕ್ಕೆ ಅವಾರ್ಡ್ ಇದ್ದಿದ್ದು ಪ್ಲಸ್ ಮಾಡಿಬಿಟ್ಟು 80,33,750 ಬಡ್ಡಿ ಹೇಳ್ತಿದ್ದಾರೆ. ಇದು ಅವರ ಟೆಂಡೆನ್ಸಿ. It is their award. Then may kindly see the proclamation at annexure C. How the bank shall notify total 33,90,423 for the bottom. Let's just see bottom.
Yes.
And upper down again, upper cooperative that down. Then the annexure P is very easy. So logic may kindly keep in mind. This is a petition filed in terms of the remedy available in the statute. Where the defaulter having the right to take an appeal to not to confirm the same in the process of confirmation of the same. Here may not what law contemplates the takeable object to the requirement under the. Here making a representation that you have conducted an auction, X is the higher bidder, you wanted to confirm it, I make a request not to confirm the same. That is not suffered under the law to oppose a confirmation of the same. Because this is a very crucial state under the provisions of cooperative society act, as well as the civility to obtain money. This is a very crucial state. Therefore, they kindly read what is the contents of this representation or a.
ಆಯ್ತು ಅದ್ರಲ್ಲಿ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿಲ್ಲ. ಆಯ್ತು. Yes.
They have not put. What I would like to say, they kindly go to page 19 minutes, what they have to taken.
Yes.
ಈ ದಾವಣಗೆರೆ ಅರ್ಬನ್ ಕೋಆಪರೇಟಿವ್ ಬ್ಯಾಂಕ್ನಲ್ಲಿ ದಿನಾಂಕ 21/5/2004 ಸ್ಥಿರಾಸ್ತಿಯನ್ನು ದೈಹಿಕವಾಗಿ 35 ಲಕ್ಷ ಹರಾಜು ಮಾಡಿ ಹರಾಜು ಸ್ಥಿರೀಕರಿಸುವ ಬಗ್ಗೆ ನಮ್ಮ ಕಾರ್ಯಾಲಯದ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅದರ ಆಧಾರದಲ್ಲಿ ಉಲ್ಲೇಖದಂತೆ ನಮಗೆ ಕಾಲುಗಳ ಪತ್ರಗಳು ಹರಾಜು 30 ದಿನಗಳ ಕಾಲಾವಕಾಶಕ್ಕೆ ಮಟ್ಟಿ ನೀಡಿರುತ್ತದೆ. This is the notice of issued before confirmation they are admitted. ವೇದಿಕೆಗಳಿದ್ದಾರೆ ಅಂದರೆ ನನಗೆ 6 ದಿನಗಳ ಕಾಲಾವಕಾಶ ನೀಡಬೇಕು. ಆ ಈ ರಾಜ್ಯದಲ್ಲಿ ತುಂಬಾ ಮಳೆಯಾಗಿತ್ತು, ಕೃಷಿಕರಿಗೆ ಹೆಚ್ಚಿನ ಅವಕಾಶ ಆಗದೆ ಆಧಾರಿತ 4 ಹೆಕ್ಟೇರ್ 15 ಎಕರೆ ಜಮೀನು ಮಾರಾಟ ಮಾಡಿ ಬ್ಯಾಂಕಿನ ಪೂರ್ಣ ಸಾಲವನ್ನು ತೀರ್ಗೊಳ್ಳಿ ಮಾಡಿರುತ್ತೇನೆ. They are not set, they are not dispersed. Your confirmation process cannot be continued because of these legal infirmities or it is beyond your authority. That was not argued, that was not granted. It should all be a defaulter before your lawsuit. Your lawsuit exercising your discretion. under Article 226 on 2 counts. One is Milord, while exercising discretion under Article 226, conduct of the petitioner before the court is one relevant factor. Second is decision taking process, how it is culminated with a process is another process. This is his conduct there. He has not raised any finger. So far as this award is incorrect and award very stipulation of quantification of liability is not correct, is not given. Then I make NDC annexed. This is the order of the assistant registrar. Is there a confirmation order that is on the 2002?
Yes.
Can you take your lordships? First paragraph, last 4 lines. Suddenly we see at the budget. Annexure of page 20. Last 4 lines in first paragraph. Suddenly we see at the budget. ಸಂಬಂಧಿಸಿದವರಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿ ವಿಚಾರಣೆಯನ್ನು ಕೈಗೊಂಡು ದಾವಾ ಸ್ವತ್ತಿನ ಪಾಲುದಾರಿಕೆಗೆ ಸಾಕಷ್ಟು ಕಾಲಾವಕಾಶದಲ್ಲಿ ಆಸ್ತಿಯ ಮೌಲ್ಯಮಾಪನವನ್ನು ಸರ್ಕಾರದ ಪೀಠಪೀಠ ಇಲಾಖೆಯಿಂದ ಮಾಹಿತಿ ಸಲ್ಲಿಸಲು ತಿಳಿಸಲಾಗಿತ್ತು. ಆದರೆ 19/6/2004 ಖಾಸಗಿಯವರಿಂದ ವರದಿ ಮಾಡಿಸಿ ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಮಾರಾಟಾಧಿಕಾರಿಗಳ ಪರಿಶೀಲಿಸಲಾಗಿ ದಾವಾ ಸ್ವತ್ತಿನ ಪಾಲುದಾರರು ಕೋರಿಕೊಂಡಂತೆ ಕೆಳಕಂಡ ದಿನಾಂಕಗಳನ್ನು ಅಂದ್ರೆ 21/4/2004, 7/5/2004, 14/5/2004, 21/5/2004 ಸಾಕಷ್ಟು ಕಾಲಾವಕಾಶವನ್ನು ನೀಡಿದ್ದನ್ನು ಗಮನಿಸಿದೆ. 7/5/2004 ಹರಾಜಿನಲ್ಲಿ ಕಡಿಮೆ ಬೆಲೆಗೆ ಹರಾಜು ಆದ ಕಾರಣ 29/5/2004 ನಿಗದಿತ ಹರಾಜಿನಲ್ಲಿ ಬಸವರಾಜ್ ಬಂದ್ ಎಲ್ಎಲ್ಸಿಯವರು 38 ಲಕ್ಷಗಳಿಗೆ ಅತ್ಯಧಿಕ ಬೆಲೆಗೆ ಹರಾಜು ನೀಡಿದ ಕಾರಣ ಮಾರಾಟಾಧಿಕಾರಿಗಳು ಸದರಿ ಪ್ರತಿಸಿರುತ್ತಾರೆ. ದಾವಾ ಸ್ವತ್ತಿನ ಇನ್ನೊಬ್ಬ ಪಾಲದ ಇಟ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್.
Sir, it's all right, sir. We accept that they have not raised these issues when they had the opportunity. This is what you are trying to say.
Yes.
For the first time, they are raising it before this court.
No, I am not on that point. I am on the point that this machinery, there is contemplated them to raise all these markets are content. There they are remedy to got it adjudicated. If it is not adjudicated, what it amounts to is knowing simply relevant practical available in law machinery. Why we are not going to avoid indication that the of their right was adjudication at the latest stage.
You please see this third paragraph, in page number 21.
Yes.
While making that order, he refers to an objection raised.
Yes.
Saying material irregularity or mistake or fraud in publishing or conducting it. One nimsha. Let us see whether the provision contemplates any responsibility on the person or authority executing the award. Is it not his responsibility to find out?
Yes. And responsibility. What provision says it?
Let us see, let us read that.
Yes.
Yes.
The kindly go to Rule 38.
Which is that provision that we pointed out that day?
Section 100. Section Rule 38. Rule 38 also I provided. So 38F.
Section 100 and Rule 38.
38F. Once it is postponed, then again paper will change the expired after more than 1 week. 38F.
ಏನ್ರಿ ಹೆಗ್ಡೆ ಅವ್ರೆ ಏನೋ ಹೇಳ್ತಾ ಇದ್ರೆ ಏನೋ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ತಾರಲ್ರಿ.
Sorry, madam. Section 100.
Section 101.
100, 101, 100 and 101.
Society is covered under section 100.
101.
101.
Please come to 101.
Yes, I am. Yes. It is also my credence.
Yes.
Referring to 101 only.
Yes.
Every order made by the registrar under section 1 of section 69 or under section 89. Every decision award made under section 71. Every order made by the legislator under section 24. Every order made by the commission under section 107. Every order made under section 106 or 108 shall to other provision of this act be binding on the persons of cooperative society against the order or decision. Award has been obtained, shall not carry out on a certificate study by the registrar or any person authorized in this behalf. The dignity or decree of the civil court shall be executed in the same manner as a decree of such court. Be executed according to law and under the rules being in force of category of
award obtained. So therefore, when the authority is required to find out what is the award. Yes, there is an award they have obtained, and therefore they are entitled for execution of the same. Is it not the duty of the executing officer to find out?
I will ask you that. I am not very fine.
Yes.
Honestly said, in fairness I said, there is an irregularity in Act 60 lakhs.
Irregularity, they don't get the power at all to execute.
Now the question would be, because if no statutory remedies are available for that, there would be an act of invalidity. Suppose a veterinarian is provocatively not to adjudicate all these things, it is a wonderful, it is not a right. We are trying to different.
No, sir. That argument cannot be accepted at all. It cannot be construed as a voidable action. Yes.
To see, I am trying to convince you a lot. This is the voidable one, not one. But ultimately, it is my hard efforts that I know I am very dangerous.
Correct. Yes.
The petition is clear.
Yes.
It is not easy for you to take your logic to say, no, whether it is not correct. I am conceding. The latter part of the amount is not the total matter of the award.
Correct.
I do concede. I executed. Take it from us, I executed. It is irregularly executed. I have not been happy. But after I executed, what is the remedy? That is my question to my certificate. It doesn't. We are not. I can see checking that this essentially exercise I wanted to render before you along.
Yes.
Let me guidance in your this. Kindly go to subsection 2 clause A. This is very important. 101 subsection 2 clause A. Notwithstanding anything contained in this code, whether my kindly see the notice language. Notwithstanding anything contained in this act, every question relating to execution, discharge, satisfaction and order, decision, award, referred to in subsection 1, relating to confirmation, setting aside of a sale, held in an execution of such order, decision, or award, in pursuance of clause 3 of subsection 1, or related to any claim or objection to an attachment of any property under 103, or in execution pursuant to the said clause 3, shall be determined by an order of the registrar or any other person subordinate to him, empowered by the registrar under the said clause 3, authorized person before. My submission to law is make a note. This word notwithstanding anything contained in this act, it automatically absolves the answer subsection 1 asks. Can I put it in this way? Section 101, subsection 1. imposes an obligation on the part of a person who has to execute the decree only on the basis of an award. Only on the basis of an award. That is very apparent. But by incorporating subsection 2, legislature anticipated sometimes execution may go beyond a very whatever may be the reason. That is the reason. The machinery is provided under subsection 2 of section 101. This is a statutory material. May I read it again not for a moment?
Yes, yes.
Can I read it?
Yes.
Notwithstanding anything contained in this act, every question may contain a rule relating to execution, discharge, satisfaction and order, decision, award referred to in subsection 1 relating to confirmation, setting aside of a state having a order, decision or award in questions of clause of subsection 1 relating to any claim or objection to an attachment of any property made under subsection 103 in execution, etc., should be decided by the registrar under section 101. Lord, this is parallelly here to section 47 of CBC. CBC is also contemplate this kind of.
Yes.
Lord, the machinery under 101 subsection 2 starts with a word and getting contained inclusive of 101 subsection 1.
Yes.
It is totally an independent. Totally an independent. All these events could fall under subsection 2 of section 101. This is first basic submission I wanted to. Then there are how that remedy may kindly go to you. There any claim is preferred. That is, any claim is preferred means claim covered under subsection 2 clause C of section 101. Against or any objection is made. The attachment or any property made under subsection section 103 or in execution in pursuance to clause C of subsection 1 on the ground that such property is not viable to such attachment, registrar or authorized person shall proceed to investigate the claim of the objectors. Then, provided that the registrar of the authorized person considered that objection decidedly and not delayed shall make such order. If machinery then may not clause 3 may be carried, so clause 2 also. Yes, I can reach the entire provision. Thereupon such investigation may kindly see. Again, investigation covered on the instances under subgroup A of section 101. After the person satisfied that further reasons stated in the claim or restrictions with property was not at the date of the attachment in possession of the person or property setting an order institution award has been obtained or some person interested in participation of the tenant, other person paying rent, development of the fee possession, such as it was in his possession, not in his own account, own property, but on account of trust or some other person, partly own account, etc., etc. Then class 3. Where the registrar of the authorized person is satisfied that property was not affected in possession of the or asset property, not on account of any other person, was in the occupancy, etc. Then when I class 4 is very important. Where a claim or an objection is preferred, where a claim and the objection is preferred, again we refer to 101 subsection class A only. Then the party against whom an order is made within a period of 1 year from the date of such order, institute a civil court, establish the right which claims to the property is issued, but subject to the result of such court, if any order of the registrar or authorized person shall be convicted. That I get these. Now, 2 questions, basic doubts which your lordships carry in their mind appears. I could able to remove. Number 1, 101 subsection 2 clause A is an independent provision. It is not regulated by section 101 subsection 1. It stands independently. It contemplates a machinery. The machinery of what kind? It is provided under clause 2A. All grievances, therefore, every case or how it is followed by 150, they continue. Every question related. Because every is an extraordinary comprehensive work. It does not want to restrict it to one instance or the other. It could be raised before the registrar. Law provides either registrar on his own, or he can empower some other authority on his subordinate for adjudication. Adjudication, after adjudication, if you are agreed, if you are satisfied, it's a society's given. If it is against the authority, you have to fail a citizen and seek resolution remedy available under clause 4 of 101 subsection 101 subsection 2. One is sufficient to logic. A kindly make what is sufficient. Suppose I have a remedy because of the flux of time and loss. Can I revive my right in an article? Essentially, my argument I wanted to.
Yes. Yes.
This is one. Second point of argument I wanted to raise. The fourth part.
ಏನಿದ್ದಾರೆ ಒಟ್ಟಿಗೆ ಏನಾರು ಇದೆಯಾ?
It's called election. Today, 22nd to 30th. Society data giving time to arbitrate it is second to 22nd, always upon period.
We'll have it tomorrow itself because anyway you are ready with this one. There's no difficulty. Please, this matters. 2nd of June. For further hearing.
Tomorrow.
2:30.
At 2:30, bro. Shall it?
Court officer? Hello, court officer? Court officer?
ಏನ್ ಸರ್ ಹೇಳಿ ಸರ್.
ಸರ್ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 48 ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇತ್ತು, ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗುತ್ತಲ್ಲ?
ಆಗಿದೆ ಸರ್, ಆಗಿದೆ ಸರ್, ಈಗಾಗಲೇ ಆಗಿದೆ.
ಸರಿ ಸರ್,
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.